Labas rytas.
Labas rytas, ar girdit mane?
Taip, mes jūs ir girdim ir matom. Viskas gerai, pasirodo, kad eina. Gal neina.
Tai prisijungęs.
Taip, labai gerai. Mes dabar dar išbandom, ar tikrai mūsų transliavimas vyksta. Ar jūs norėsite pasidalinti kažkokią prezentaciją?
Ne, senamadiškai tik tai kalbėjimas.
Gerai, puiku, puiku.
Tai aš dabar kaip galiu palikti šitai prijungtą?
Taip, dabar galite visiškai taip palikti.
Aš turėsiu dar tą pusvalandį.
Taip, mes jūs ir girdim ir matom. Viskas gerai, pasirodo, kad eina. Gal neina.
Labas rytas, profesoriau, malonu matyti.
Sveiki, kas čia Justinas?
Taip, Justinas.
Bet aš nematau paties, klausyk.
Aš matot dabar esu saviizoliacijoje, tai truputėlį toksai slepiuosi trupučiuką.
Aš kaip, o kas privertė izoliuotis?
Kontaktą turėjau su COVID-19 žmogumi.
Oi, klausyk. Nu, tikėkime, kad nieko neįvyko.
Aš irgi labai tikiuosi.
Nu, tai nieko, dabar tos konferencijos.
Taip, galim pasisveikinti.
Jau dabar matau.
Sveiki.
Gerai.
Malonu.
Tai iš namų?
Jo, iš namų.
Iš namų, nu aš irgi iš namų.
Nu taip, puiku. Tada.
Kaip čia man padaryti, jūs taip gerai atrodo, o aš, dabar atitraukiu gal. Ar čia galim kaip nors reguliuoti dydį?
Dydžio negalite, bet galite truputį, pavyzdžiui, kamerą nukreipti žemiau arba truputį toliau. Taip, bet jeigu žemiau...
Aš patraukiau, tiesiog pastumiau ją, aišku.
Taip, galite pastumti.
Mano fizionomija užpildė visą tą kvadratėlį. Tai kiek čia tų kvadratėlių bus mūsų?
Žinokite, tik tai pranešėjai prisijungs su kamerom, visi kiti prisijungia, nematomi, sakykim taip.
Aišku.
Taip, tai pranešėjai pirmoji sesijoje bus 4.
Aš programą mačiau, jo.
Taip, o dalyvių prisiregistravo apie 150.
Oi, tai visai nemažai.
Taip, bet visi negalės prisijungti dėl tam tikrų apribojimų, tai mes iki 100 leisime prisijungti galbūt, žiūrėsime, kaip internetas mums leis, o visiems kitiems siūlysim žiūrėti tiesioginę transliaciją, kuri yra jau paleista.
Aišku. Tai gerai, aš paskui atsijungsiu kažkada, aš tikrai negalėsiu būti visą laiką. Savo atskaitysiu ir dar gal kažkiek tai po to, paskui pabėgsiu. Justinai, kaip ten paskui kažkokia diskusija, ar labai blogai bus, jeigu aš jau joje negalėsiu būti?
Aišku, smagiau būtų, kad galėtumėt būti, bet pasižiūrėsim. Jeigu jūs matote, kad pabėgsite, tai galime iš karto po jūsų pranešimo tada diskusijai paskirti keletą.
Ta prasme, jeigu man kas turėtų klausimų, gal gali duoti klausimų iš karto, bet aš dabar žiūriu, kada diskusija 11:40, taip?
Taip.
Tai mano laiku 10:40. Nu, tai tuo metu aš dar galiu būti. Nu, apie kokį pusvalandį, sakykime.
Tai gerai, žiūrėkit, gal
tada aš iki diskusijos galo nebesugebėsiu, bet sakykime, pradžioje diskusijos galiu būti.
Supratau. Gerai, tvarka, tai tada susižiūrim pagal aplinkybės. Jeigu ką, žinot, galima padaryti, pavyzdžiui, po jūsų ir po Dainiaus Žalimo pranešimų galim padaryti pirmą diskusijos breiką, tada tikrai galėsit būti.
O kam tada tą kitą žmogų diskriminuoti? Netgi 2?
Ne, taip, o paskui jau su jais dar diskusija, dar vieną.
Nu, kaip jums patinka, viskas gerai, nes aš norėčiau apie kokią 11 valandą mūsų laikų, tai reiškia 12 jūsų laikų atsijungti. Nes man reikia,
supratau, gerai,
man reikia eiti darbą tiesiog, tai aš jau neturiu kaip
aišku,
dviejose vietose negaliu būti.
Gerai.
Gerai, tai aš ateisiu po kokių 15-20 minučių.
Puiku, gerai, ačiū.
Tikėsimės neatsijungs. Gerai.
Iki.
Okay, good morning, dear participants. We want to start our conference, and I would like to start with some technical issues. As you have noticed, you all are admitted with your audio and your video switched off, and we would like to ask you to keep it like that until discussion starts. And only our presenters are asked to switch on their audio when they are speaking and to switch on their video. As we are seeing already, Professor Kouris is already visible. He will start the conference in the first part. And now in a few minutes we will start. We will have our opening speeches, and with the first opening speech, the Dean of the Law School of Mykolas Romeris University will start, Professor Lira Jakulevičienė. In a few moments, we will start. Thank you.
Good morning, distinguished speakers, dear participants. On behalf of Mykolas Romeris University Law School, I would like to welcome you to this very first fully online at Mykolas Romeris University for the first time conference on human rights and the 70th anniversary of the European Convention of Human Rights. As most of us coming from this field know that human rights protection is never without a challenge. But the convention is being celebrated, its anniversary is being celebrated in a very particular time, and especially challenging time. Human rights are more at stake in the time of peace than ever. As we are aware, many countries in other regions and also Europe have introduced numerous restrictions on human rights due to COVID-19 pandemics. And these restrictions, they pose numerous questions as to their proportionality, balance between the needs of the society and the individual, the extent of state powers, and similar questions. While the convention, when it was adopted, it was indeed adopted in the context of the aftermath of the World War II. And it was adopted to prevent, with the purpose of preventing the atrocities, impunity from happening again. Now, if we see what's happening in Europe right now, when the Europe and world is finding with our invisible enemy, if I may say so, in the name of COVID, opinions emerge that indeed this is also a kind of war. And in this war is posing huge challenges to human rights as well. So the expectations from the convention, from the court, will be really very high to balance those diverging interests. But if we leave for the moment the pandemic situation aside, and if we look at the 70 years of existence of the convention, then for sure it has proved itself to be as a very flexible document, which reflected the developments of human rights standards, of values, of emerging needs. And having been amended and supplemented for 16 protocols, I think we all can say today that it serves as the most effective human rights protection mechanism system that goes really, and effects of it goes well beyond Europe. But the achievements of in human rights field, as we also know, should never be overestimated. as long as we have problems with the rule of law in some of the EU member states, when migrants are still dying in the Mediterranean, when we have political opponents who are imprisoned or poisoned in Europe. So today, Convention is faced with numerous challenges. And among more relevant challenges to the Convention itself, to its mechanism, including the enforcement of the judgments in some of the countries. Also, one may say it's a success, the high number of applications, but on the other hand, the high number of applications poses the challenge of delays of processing, and also the criticism that the optimization measures to address the delays in the procedures and in examination of the claims, that these optimization measures sometimes indeed leave some individuals unprotected. And today, my dear colleagues, I would have wished to invite you just to celebrate the 17th anniversary of the Convention. But as a human rights lawyer, I also wish to invite you to discuss the difficulties and solutions that human rights in Europe face today. And I also express hope that the Convention and the Court will withstand that political populism that we see in Europe now, and also risks dictated by the emergencies. Of course, using this opportunity, I would like to express my gratitude to all the distinguished speakers. It's amazing to have such a group of distinguished speakers today. And maybe this is one of those moments where probably COVID has helped us, because otherwise face-to-face probably it would have not been possible to bring all these speakers together. So thank you very much for agreeing to share with us your views and experiences. I thank you, participants who embarked on this different way of communicating in this time. And of course, our organizers, the Institute of International and European Union Law of Mykolas Riomeris University, the Human Rights Laboratory, and of course, I cannot not mention particularly Katarzyna Miksza, who has made this important gathering possible. So I wish you inspiring and constructive discussions today. Thank you.
Dear participants, unfortunately, Mr. Flaherty was not possible. The director of the European Union Fundamental Rights Agency was not able to join us live. However, he shared his greetings with us, and now I will share with you those greetings. So please have an attention now.
Very great pleasure to join with you today on the 30th anniversary of the university, as well as in honor of the 70th anniversary of the European Convention on Human Rights. And if I may add, also the 20th anniversary of the negotiation of the European Fundamental Rights Charter. I'm very sorry that my presence is virtual and that I can't be with you, not least because I missed the opportunity of joining together with the new member of the Fundamental Rights Agency Management Board, Professor Dr. Lira Yakulevechene. I've been asked, colleagues, to speak to the issue of fundamental rights catalogues and times of crisis. I welcome this opportunity because it speaks to much of what I have been doing during my career. Almost 30 years ago, I was in Bosnia-Herzegovina on behalf of the United Nations, tasked with chronicling the conflict there in terms of human rights. It was a new kind of work. We weren't sure how to do it. We had only limited success, reflected in some reference to human rights in the peace agreement, some reference to human rights in the eventual prosecution of war criminals. A few years later, another conflict, Sierra Leone in West Africa. Again there, I had a similar task with some more experience to build on, and we indeed had more success. By framing the conflict in terms of the human rights categories, we were able to put human rights strongly in both the peace process and the peace agreement, and human rights was very directly visible in terms of the prosecution of war criminals. Fast forward to today, we are all immersed in a common crisis, this time not of conflict, but no less significant and problematic for that. And just as those conflicts were profoundly issues of human rights, so today's crisis of the COVID-19 pandemic. This is an issue of human rights from at least three directions. In the first place, it's about upholding, standing up for the human rights of health and of life itself. It's an issue of human rights in terms of the limitations to our rights and the extent to which those necessary limitations of our rights respect such important legal principles as necessity, proportionality, non-discrimination, and even legality itself. And third, and no less important, this crisis is one of human rights because of its impact and the impact of the measures to tackle it on already marginalized groups, people already on the edges of our societies, such as, for example, the Roma community, about which my agency is particularly concerned at the present moment. And so we are in a crisis of human rights, and yet we face a paradox. This crisis of COVID-19 is rarely spoken of as an issue of human rights. We don't see human rights full center of decision-making, at least not expressly so. National human rights institutions are doing their best, but I think we as societies need more. We need more visibility of human rights to guide our policymakers in the crucial decisions for our lives and our welfare. Today, I will focus the attention on the role of academics. I applaud what academics, including many of you, are doing in response to the situation, but I would suggest we can do still more. Medium and long term, in terms of our academic writing and our contribution to jurisprudence, but also right now, in terms of the public debate, bringing our human rights normative, legal, intellectual contribution into the contemporary debates at national, regional, and international levels, drawing on the European Convention on Human Rights, the other instruments, our constitutions, but also, most relevantly, on the European Charter of Fundamental Rights. Much of the impact of COVID and the responses engage EU competency. We should make the Charter far more visible in our reflections on the issues that arise. It's not either or, by the way, convention or charter. To the contrary, they're profoundly interactive. And in order to understand the Charter, we must pay close attention to the provisions and the jurisprudence of the convention. Now, as you negotiate your way through these issues, I can offer you the solid support of the EU Agency of Fundamental Rights through our work, our analysis, and our engagement. And of course, I wish you all the best for today's event. Thank you.
Dear participants, we are finishing our opening speeches part, and we would like to start with the first part. The moderator of this part is a professor of the Institute of International and European Union Law, Justinas Žilinskas. And please take your chair.
Dear participants, it's a great pleasure, first of all, to be here. Well, even though here sounds quite strange these times because we are somewhere in a cyberspace, and perhaps nobody of us thought previously that the conferences might be held that way. But that's life, and that's how we do, and it's really very nice to have you all here, all the distinguished participants, all the listeners, and I think that the topics that we will address today are still important, despite of the fact that we are meeting behind the screens and not in a big room, and we can wave to each other, but we cannot shake hands. But It happened so, and let's hope that this situation will not last long. And without many ado, I would like to invite our first speaker, the distinguished judge of the European Court of Human Rights, professor and former president of Lithuanian Constitutional Court, Egidijus Kūris, as well as dear teacher of mine. So Professor Kūris, the floor is yours. We are eagerly waiting for your speech. Thank you.
Now you hear me, yes?
Yes, now we hear you.
Okay,
Please.
thank you. Thank you, Justinas. Dear Mr. Chairman, esteemed colleagues, I thank, first of all, the organizers for being able to be part of this electronic conference. The subtitle of the conference mentions challenges, and indeed the organizers of this meeting face not a small challenge when arranging it in these very surreal times. The subtitle also contains the word prospects, and I wish all the participants of our meeting and the university which is holding it the brightest prospects. And now I move on to my presentation, which is entitled The Convention as a Living Instrument. So the locution that the convention is a living instrument has become a commonplace adage, and the convention is seen not as not carved in stone once and forever, but as gradually evolving through its interpretation in the case law of the European Court of Human Rights. Yet in 1978, in a case called Tyrer versus the United Kingdom, the court stated that the convention, and I quote, is a living instrument which must be interpreted in the light of present-day conditions, end of quote. This was repeated in numerous subsequent authorities, including, for example, Valianatos versus Greece of 2013, which is mentioned in the invitation to this electronic conference. In the court's words, I quote again, the provisions of an international treaty, such as the convention, must be construed in the light of their object and purpose, and also in accordance with the principle of effectiveness. I took this quotation from Mamatkulov and Askarov versus Turkey from 2005, but there are many other authorities which cite the same words. These short citations do not exhaust the richness of the living instrument doctrine, but they are sufficient, in my mind, to assert that the court has openly acknowledged judicial creativity and judiciary's role in law making, in convention making in this case. This is a pragmatic stance, for it is inconceivable that every time when some new present-day condition, whatever it may be, legal, social, ethical, technological, or maybe related to scientific developments, comes into being, a formal amendment to the convention must or can be introduced by the high contracting parties themselves. Thus, the living instrument doctrine in action is the antidote to the otherwise unavoidable inefficiency or even paralysis of the convention system. From a methodological point of view, from the methodological perspective, this doctrine is the court's response to the strict originalism according to which a judicial departure from the legal text amounts to lawmaking in which courts allegedly should not engage. The living instrument formula has been repeated in relation to the convention in numerous judgments of the court. I already said that. These iterations travel indeed from case to case. Sometimes the living instrument argument constitutes an important part of the court's ratio in a case at hand. This is so where the court modifies its interpretation of conventional provisions, let alone reverses its established case law. The formula living instrument is also employed where the court, in a follow-up manner, reaffirms its recent doctrinal innovations. In other cases, the characterization of the convention as a living instrument is only not a ratio, but a dictum. For if one applied the famous Wombos inversion test, one would see that even if the formula in question was omitted, the case would have been decided in the same way, and the court's ratio would not require any extra explanation. Such mere mentioning of the living instrument formula redundant as it may seem for the purposes of that particular case, is still meaningful in its own right, because it is a manifestation of one more pattern of the consolidation of the evolutionary approach, which is not compromised by repetition. Thus, the evolutive method has become one of the underlying methods in the court's arsenal of tools for the interpretation of their convention. True, analysts and commentators must not always agree with the employment of this tool in concrete cases, in each and every case. It happens that they criticize its use. So may do, and really do, judges in their dissents. Law's jurisprudential evolution has never been free of contradictions. That notwithstanding, one could assert with high degree of certainty that the majority of analysts and commentators have in principle accepted the evolutive method. Sometimes the parties or the third-party interveners, they explicitly request the court to employ that method and even to overturn its earlier doctrines. Here is one example of such a request, in this case by third-party interveners. Let me quote: "The Grand Chamber could not interpret the convention solely in accordance with the intentions of its authors as expressed several decades ago, at a time when only a minority of the present contracting parties were member states of the Council of Europe. Thus, the Grand Chamber is not bound to follow its previous judgments, but ought to interpret the convention as a living instrument in the light of present-day conditions." End of quote. And the quote comes from a landmark, I would say really landmark case, Magyar Helsinki Bizottság versus Hungary of 2016. So to be sure, interveners, parties, third-party interveners' wishes need not always be heeded. And that applies to this request too. And they need not to be fulfilled. One of my favorite songs, Simon and Garfunkel's song, "Keep the Customer Satisfied," which was written 50 years ago, is a great song, but its title is not a guidance to courts. I already mentioned that the living instrument doctrine is a rejection of the originalist approach. The starting point, however, of genuine originalism is a powerful moral imperative. It says that what compels a court to interpret a legal act so that its interpretation does not depart from its original intent is an obligation to respect the founding fathers, their will. Chester James Antior, a very distinguished scholar, postulated this imperative in the context of constitution or constitutional adjudication, but one can direct it also to international treaties, the convention being one of them. From this point of view, the evolutionary approach to the convention amounts to the justification of usurpation by the court of the high contracting parties' treaty-making powers. Criticism based on this paradigm is voiced with respect to the court's case law on, say, rights of prisoners or homosexual persons or migrants and so on. That criticism may be of cultural origin, of root, or it may be rooted in religion, or it may be and sometimes is undisguisedly political. Other factors aside, from a purely legal standpoint, the court is reproached sometimes for deflating the probative value of the convention's text and its travaux préparatoires, which reveal the original intent of the founders. The Strasbourg court is no exception in this respect. The criticism that the original intent is ignored sometimes is imparted with regard to virtually all judicial and quasi-judicial bodies, international and national, in all regions of the world. I myself got somehow used to that in my previous life of a constitutional judge. The fact that the living instrument formula has been coined in Strasbourg must not overshadow the fact that the evolutive method is not Strasbourg's invention. It is part and parcel of legal interpretation as such, and thus of any judicial practice, not only interpretation of the convention. But let us ask ourselves, is the evolutive interpretation irreconcilable with respect to the Convention's founders? To which extent the 8 volumes of Travaux Préparatoires immobilize the living instrument doctrine? And do they at all? My point is that the Convention and its Travaux not only do not preclude evolutive interpretation, but even anticipate it. The Convention, as an international treaty, must be applied and interpreted in accordance with the general rules of international law, in particular, the Vienna Convention on the Law of Treaties. The way to modify the Convention, thus, would be to follow the so-called normal procedure of amendment. But that does not shut the door for its evolutive interpretation. The Convention is an atypical, a very distinct international instrument. Its interpretation is in many respects akin not so much to that of other international treaties, but to that of national constitutions. Even if, contrary to increasingly publicized approach, the Convention is not a constitution, and the Strasbourg Court is not Europe's constitutional court. The preamble to the Convention refers to the maintenance of human rights and fundamental freedoms, but also to their, I quote, further realization. Thus, it treats conventional rights and human rights in general, not as static, but as capable of dynamic evolution. The living instrument doctrine, thus, has been developed not outside the Convention, but is rooted in it. It ensures the Convention's vitality. Many conventional provisions are worded in generic and laconic terms and are susceptible to the epithet which decades ago HLA Hart aimed at constitutional provisions. And that epithet is magniloquent phrases. Take, for example, the most laconic article of the Convention, Article 3. They naturally intrinsically call for creative interpretation and thus reflect the intention of the founders to produce the Convention capable of continuous and progressive development. The presumed general direction of that progression is clear. It is the further realization of human rights, which, in its turn, encompasses a judicial imposition of new, higher standards of human rights protection. Thus, evolutive interpretation is not an antithesis to the founders' original intent, but part of that intent. The Travaux are an important tool of interpretation of the Convention, but they are but just one of the tools and not a trump card. There may be cases where there are good reasons not to give the Travaux the decisive weight. According to Article 31 of the Vienna Convention, the general rule of treaty interpretation is that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. That article does not include the Travaux as an obligatory source of treaty interpretation. Instead, Article 32 stipulates that, I quote, the preparatory work of the treaty and the circumstances of its conclusion are a supplementary means of interpretation to be used in order to confirm the meaning resulting from the application of the general rule of treaty interpretation, or to determine the meaning when the interpretation leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or unreasonable. The International Law Commission, while recognizing the value of the Travaux to various international treaties, had underlined its limits. The International Court of Justice has pointed to the fragmented character of some of the Travaux to some of the treaties. All this testifies to the same effect as the logic of the Vienna Convention. These general considerations are fully applicable to the interpretation of the Convention. The result is that not only the doctrines, the partial doctrines pertaining to the interpretation of particular conventional rights and freedoms, but also the major methodologies developed by the court and underlying its judgments, such as balancing of rights, quality of the law, proportionality, margin of appreciation, and so on, you name it, are results of evolutionary approach. The question, however, remains, has the evolutionary development of the convention any limits? It has. There are doctrinal safeguards against excessive judicial license. They may be efficient if properly applied. True, opinions may diverge as to what in a concrete case would be proper and what not. These safeguards, seemingly evident as they are not in themselves unproblematic. The underlying tenet is, however, clear, that the court cannot create, by means of interpretation, a right of freedom which is not enshrined in the convention. In a similar vein, it cannot narrow a conventional right of freedom so that its very essence is leached out or otherwise negated. This seems rational and fair. This general tenet can be displayed as encompassing three main limitations. The first limitation is the following. The interpretation must be either intra legem, which is the first preference, of course, or praeter legem, but not contra legem. It must remain within the limits of the terms used in the convention and not conflict with them. The irony is that it is no one else but the court itself who interprets the meaning of the conventional concepts, which, according to the court's doctrine, are not only generic, but also autonomous from whatever meaning these concepts may have acquired in domestic law. As long as the member states have not clearly rejected a particular judicial interpretation, which was, say, for example, with the death penalty or expulsion of aliens, which were the subject of subsequent later protocols, the court has the power to determine the meaning of the language of the convention. That power even may be said to grow with the time which has passed since that wording was chosen. The second limitation is such. The interpretation must be compatible with the object and purpose of the convention in general and of the respective provision in particular. This is the general principle of any legal interpretation. Difficulties may arise when the original purpose of the provision diverges from the understanding of a particular right which prevails today in Europe and which is different, sometimes very strikingly different, from its understanding at the time of the drafting of the convention. And the third limitation is the following. The interpretation must reflect identifiable new conditions. New conditions. These conditions must represent the present day and not an anticipation of what may take place in the future, because no one of us has a gift of prophecy. This principle commands the search for what is called a European consensus, which indicates a common acceptance of the interpretation in question. It can manifest itself in many forms, and first of all, and most notably, in the prevailing legislation and practice of the Council of Europe's member states. The tricky thing is that, as was put by late Lucius Willhaber in his seminal article, which was called No Consensus on Consensus from 2013, there is really no consensus on what is meant by consensus. The notion of consensus thus is somehow comparable to what Walter Bryce Galley, a prominent philosopher, called essentially contested concepts in his article of 1956. Must all those three limitations always be observed to allow for a doctrinal innovation, or maybe sometimes less can suffice? For these three conditions may compete. For example, what if the present-day conditions command a progressive evolution of a human rights standard, but such an interpretation would be contra legem? This is not only a theoretical question. This question sometimes manifests itself in practice. All in all, the court attempts to respect all three limitations. Still, the conventional jurisprudential evolution is not a one-way street. there have been instances of, so to say, more lenient approach to some of them, as well as of moving in the direction of judicial imposition of higher human rights standards in some fields, while self-restraining from doing that in other fields. Even more, there have been back and forth movements in the same field. Due to time constraints, I shall not expand much on the illustrations of this contradictory or partly contradictory development, but allow me to mention a few examples along what appear to be the three lines of the court's case law. The first line is where the court has progressively and steadily imposed higher human rights standards. It includes, for example, cases where the court has maintained that for Article 6, paragraph 1, in its civil limb to be applicable, there must be a genuine and serious dispute over a right which can be said, at least on arguable grounds, to be recognized under domestic law, irrespective of whether it is protected under the convention. The court has constantly held that it may not create, by way of interpretation, a substantive right which has no legal basis in the state concerned. Still, maintaining a distinction between procedural and substantive elements of non-conventional right, it has granted the latter's procedural protection under the convention. As to substantive rights enshrined in the convention itself, one example of progressive imposition of higher standards is the court's movement in only 5 years, from 2008 to 2013, from Kafkaris versus Cyprus, in which the life prisoner's so-called right to hope was not acknowledged, to Winter and others versus the United Kingdom, and the subsequent line of the case law, including one case against Lithuania, in which that right has been consolidated. Among other manifestations of the evolutionary development, one could mention the cases consolidating the standards of the detention conditions, such as, for example, the 3 square meter space requirement for inmates, including the landmark case of Mursic versus Croatia of 2016. And a truly, my favorite truly spectacular example is Magyar Helsinki Bizottság versus Hungary, in which the court, at last, after all national courts of all countries, held that Article 10 enshrined not only the right to receive and impart information, but also to seek it. The second, somewhat opposite line of case law is where the court has resisted the imposition of higher standards. Take, for example, the dismissal as incompatible ratione materia with the provisions of the convention of the complaints in a case called Károly Nagy versus Hungary of 2017. The applicant was a priest, and he had a pecuniary dispute with his church, which was decided by the ecclesiastical jurisdiction. The Grand Chamber's majority held that that dispute was excluded from the protection under Articles 6 and 13. And no less characteristic example would be Hudorovic and others versus Slovenia, a very new case of this year, in which the chamber, not a Grand Chamber, the chamber was reluctant to defend the applicant's right to water, not, of course, not enshrined in the convention, but explicitly consolidated in Slovenia's constitution. But an even more pronounced example would be Johnston and others versus Ireland, a very old case of 1986, in which Article 12 was interpreted as not encompassing the right to divorce. This restrictive, and I would even say even illiberal doctrine, coined in the era of prohibition of divorce in Ireland, which ended in 1995, was recently reconfirmed in the case called Babiarz versus Poland in 2017. An opposite, victim-friendly interpretation clearly would have corresponded to the all-European consensus, because all countries allow divorce, and the present-day conditions. In it, if it would have been contra legem, or if I may use such a term, contra travo, so was that in Magyar Helsinki Bizottság. And there is also the third line of case law. It happens that the court, having moved in the past in the direction of what was seen as higher standards, retreats and lowers them. One example is Nicolae Virgiliu Tănase versus Romania, a case from 2019, where the court, reversing part of its earlier case law, took a very restrictive generalized approach to cases in which the victims complained about the inefficiency of investigation of injuries caused to them by negligence of third persons. Such complaints were found to be incompatible ratione materia with Articles 3 and possibly with some exceptions, Article 8. A more positive example of a reversal is Denisov versus Ukraine, a case of 2018, where the Grand Chamber distanced itself from the overly expansive approach to dismissals of court presidents as something covered by Article 8, separately from their dismissals from the judiciary, the approach which culminated in a case called Ermeni versus Hungary of 2016. Finally, there have been cases in which the narrowing of the conventional protection stems from the development in domestic law. For example, the court, having long held that the constitutional complaint in Hungary was not an effective remedy, and that was stated, for example, in a case called Karachin and others versus Hungary of 2016, finally admitted in two decisions of 2018 and 19, they are called Mendre and Solontai, it admitted that that remedy was effective. But the latter development pertains more to the application of the convention than to its interpretation. The three trends coexist and compete to some extent. The first one is seen as a dominating, and the court may be, and in fact is, praised for keeping to it. But the two others should not be ignored, especially in the context of newly emerging present-day conditions which the court may be compelled to pay heed to. For example, it is yet to be seen what will be the impact of the court's case law of the current greatest challenge. I mean the ongoing pandemic, which was the cause of or sometimes the pretext for the restrictions of various rights. The right to life, the freedom of movement, the right to access to court and to trial within reasonable time, the right to peaceful assemblies, the freedom of expression, and so on. The list is not exhaustive. The pandemic clearly is not only an exemplification of what the living instrument doctrine calls a present-day condition. It is such condition par excellence. To speculate now on these future developments would be perhaps ill-advised and too early. They may involve new instances of back and forth movement, but it may also be so that in view of the insistence that hands must be watched, ceaselessly repeated on TV all over the world, cases like Hudorovic, which I already mentioned, on the right to water, and it concerned the Roma community, which Professor Flaherty already mentioned, and that case was deliberated only on the 4th of February 2020. Such cases might be decided in a more applicant-friendly way. To sum up, the court's evolutionary practice, rationalized and justified by the living instrument doctrine, has not been 100% consistent, for it is not only the convention which is living, which is a living instrument. The court is also a living body consisting of living judges. Being living always intrinsically encompasses some unevenness, even if some developments may be seen by some as setbacks. In overall, the court has been quite successful in elaborating progressive human rights standards higher than envisaged by the founders, but in line with their general intention that the protection of human rights may and must be furthered and progressing. I thank you for your attention, and please excuse me if I shall not be able to be with you throughout all the conference, but because I will have to go and resume my work, but I will be in the first part. Thank you very much.
Thank you very much, Honorable Judge and Professor Kouris. I guess that such an impressive bird view, or should I say drone view, on the convention is indeed extremely interesting. On the other hand, I hope that some of the politicians who are constantly saying some mean things about the court and how the court acts will listen to this report and will try to think how complicated system of European Court of Human Rights and jurisprudence is, and what a great instrument we have. Now I would like to pass the floor to the current president of Lithuanian Constitutional Court, our dear colleague Dainius Žalimas. I see him on screen. He's still adjusting his view. So Dainius, welcome, and the floor is yours.
Can you hear me? Everything
yes, we can. Yes, we can. Yes, please.
Thank you. So let me first to express my gratitude for the invitation to participate in this conference. And of course, let me to congratulate all of you with a remarkable event, 70th anniversary of the European Convention on Human Rights. I would like to stress its particular role in the countries, in the post-communist countries like Lithuania, because if we don't have this important international European instrument, of course it would be much more difficult sometimes to reject and to disperse quite widespread stereotypes in our society, justifying various kinds of discrimination, for example, based on sex, on sexual orientation, sexual identity, and many other things. So it's a really living instrument. May I continue my the previous speaker, really living instrument, which makes also the constitution also living instrument, because without the convention as the tool for interpretation of the constitution, we wouldn't have maybe to large extent also the notion of jurisprudential constitution, or the notion of a constitution as the living instrument as well. You know, the theme of my presentation actually was provoked a little bit by the renewing debates among lawyers in Lithuania, first of all, among traditional constitutionalists, let's say, and international lawyers. Both sides, by the way, always pretend and argue for the superiority, either international or the constitution. And just recently, the Constitutional Court has been criticized because it uses allegedly too much international law, including convention, and the European Union law in particular. May I recall some of the recent, let's say, decisions and judgments of of the Constitutional Court, where it simply established the rule that there is no ground to interpret the Constitution in a different way from the law of the European Union. Because it is the Constitution itself establishes the rule of sharing state competence with the European Union. And in those fields, really, there is no constitutional ground to understand, for example, or to perceive the rules of competition or internal market in a different way under the Lithuanian constitution. Of course, this rule always may have certain exceptions. I'm going also to touch them. And of course, my main, let's say, idea of this presentation is also that there is no real ground not to accept or not to treat the convention as the source for the development of a constitutional doctrine, of the official constitutional doctrine. And that's why the constitution should be also perceived as one of the most important sources for the interpretation of the constitution. Although I fully agree that not all constitutionalists, let's say, would agree with me, but still here is also one of the proofs that the constitution is also a living instrument, because if we recall the first, let's say, judgments or rulings of the Constitutional Court, or conclusions regarding the convention, we all remember that initially the convention was treated as simply a kind of ordinary law in the Lithuanian legal system. Later, the court had to conclude that it has the priority of application over other laws, because otherwise it wouldn't be impossible to guarantee the implementation of international obligations. And now I am arguing that the convention should be perceived, although of course the constitution preserves its superiority, but the convention should be perceived as one of the most important sources for the development of official constitutional doctrine, and that for the interpretation of the constitution itself. Let me begin that, of course, according to the constitution and to the letter of the constitution, the convention formally has lower rank of legal force in Lithuania. Article 7 of the constitution clearly provides that no legal act, including the convention as the constituent part of Lithuanian legal system, can be contrary to the constitution. However, just also we should take into account that already in 1995 the Constitutional Court itself characterized, let's say, described the convention as an exceptional instrument of international law. Exceptional because it plays the same role as the constitution, of course, on international arena, first of all, because it establishes a certain catalog of human rights and also provides the mechanism for their protection. And main question is here whether the constitution itself allows to rely on convention when interpreting its provisions, despite of the fact that, of course, according to the constitution, according to the letter of the constitution itself, the convention is the act of a lower rank. Let's look simply at the facts. Almost in 20%, more or less, of constitutional justice cases, the Lithuanian Constitutional Court makes references to both the convention and the case law of the European Court of Human Rights. And most often it's simply, we can call like copy-paste of the doctrine developed by the European Court of Human Rights. It seems that the same provisions that already stated in the case law of the European Court of Human Rights, they simply are repeated as the provisions of official constitutional doctrine. And this fact, I think, it speaks for itself, that really we can speak about artificial delimitation between convention and the constitution, about superiority of the constitution, but nevertheless, in 20% of cases, the official constitutional doctrine is developed on the basis of the European Court of Human Rights case law. And my argument is that the constitution not only allows to rely on the convention, but even it is the constitutional imperative to rely on the convention while interpreting the constitution. And why? First of all, I think there is nobody could object that both the convention and the constitution has the same purpose. That is the protection of universal, first of all, because I don't think human dignity, for example, human freedom, human life can be different in essential elements in different European countries. So really, both the convention and the constitution share the same purpose, the protection of universal and inherent human rights. And once the Lithuanian Constitutional Court already established in 2014 that inherent nature of human rights is eternal constitutional value. It cannot be abolished by any constitutional amendments. That is the eternal constitutional principle or unamendable clause. And once the Lithuanian Constitutional Court already also established in the same year of 2014 and just repeated in July of this year, 2020, that one of the material limitations for the constitutional amendments is prohibition of such constitutional amendments that would be contrary to the existing international obligations, including the convention, by the way. We can't make constitutional amendments that would be contrary to the convention. I think it's the first point to say that the convention should be presumed as compatible with the constitution, and of course should be presumed as one of the sources for interpreting human rights according to the constitution. So we have presumption of the compatibility. The next important, I think, principle, that the convention should be also understood as constitutional minimum for the protection of human rights. I would stress that constitutional minimum. And later we will develop it. Sometimes we can derogate from the rule that we should interpret constitution according to, strictly in line with the convention, if the constitution can provide higher standards for protection of certain human rights. And I think the good constitutional basis for treating convention as one of the sources, and one of the most important sources for the interpretation of the constitution, are four constitutional principles. I think they are more or less typical, except maybe one, for all the European countries. They expressed maybe in some different wording, but still. So the first principle is the principle which is universal idea of constitutionalism, a universal idea of the convention itself. It's simply the rule of law. Yes, the constitution establishes that Lithuania should be the state under the rule of law. And what is the rule of law? The rule of law, it includes not only the imperative of supremacy or superiority of the constitution, but as well as the respect for international law and respect for convention, respect for human rights. So, of course, I fully assume that it is, first of all, constitutional responsibility of the Constitutional Court to find the ways how to reconcile these imperatives. But it's the basis that once we established the rule of law, so the rule of law, it also implies not only the supremacy of the constitution, but at the same time also the respect for universal human rights and for such instruments as the convention. And the second, maybe more, let's say, specific principle, respect for international obligations. It's also included in the text of the Lithuanian constitution. It is also very, let's say, closely related with the next important principle, the principle of open civil society. And the Constitutional Court already, when proclaiming death penalty as unconstitutional, already stated that the principle of open civil society, later it was repeated in 2014 in famous genocide case, let's say, it was clearly stated that the open civil society means openness to international community, openness to international law, and there is no constitutional reason to isolate constitution from the progressive development, including the progressive development of the convention as the living instrument. Unless, of course, we would prefer to choose the way like the recently chosen by the Russian Federation, which openly proclaimed in its constitution that it may reject any case law of any international tribunal, including the European Court of Human Rights, if the Constitutional Court, for example, proclaimed that this kind of development of international law is contrary to the fundamentals, not fundamentals, of course, includes human rights, but to all the fundamentals of the constitutional order. So if we have open civil society, we cannot also isolate constitution from the development of human rights law. And the last principle may be more typical for Lithuania. It's national let's say, it's a part of national constitutional identity, Western geopolitical orientation. It includes, for example, membership in the European Union, and membership in the European Union is inseparable from the respect to the European Convention of Human Rights. So, having in mind all these principles as a complex, which simply inevitably come to the conclusion that as a consequence there is a duty of the Constitutional Court under the Constitution when interpreting the Constitution, of course in human rights sphere, also to take into account the convention as one of the sources. And of course, I can mention here a number of examples where it has been actually done. For example, we remember two cases on the concept of family, one of 2011, the second of 2019, where the Constitutional Court, also relying on the European Union law, of course, on the also quite extensive case law of the European Court of Human Rights, simply proclaimed that family life should be defended or should be protected at the same level for same-sex couples as well, and that the concept of family is gender-neutral family, that is also taken from the progressive development of the European Court of Human Rights. And what is more important, we all know that in states like Lithuania, I guess around 70 or even more % of population are against such treatment of human rights. But here the convention, including the case law of the European Court of Human Rights, serves simply as a shield for the progressive development of the official constitutional doctrine. I could mention also much more examples, maybe not so important, but still, where, for example, in one of its rulings of 11th October 2018, the Constitutional Court relied on the case law of European Court of Human Rights while providing criteria for and formulating criteria in the official constitutional doctrine for the provision of a state-paid legal aid. So the main idea is no need to invite no need to invent a bicycle in the field of human rights, and there is all constitutionally justifiable to rely on the convention, and especially in much richer case law of the European Court of Human Rights by developing official constitutional doctrine. But this rule can have exceptions. As I mentioned, one of the exceptions is simply the Constitution can provide higher standard when established by the Convention. It's quite rare cases, but still, for example, in the last ruling adopted on 11th September 2020, the Constitutional Court faced the problem of a compulsory membership in the professional self-governing bodies of like associations and by its higher standard under the Constitution, because we know all, and the Constitutional Court also demonstrated in its ruling, that according to the Convention and according to well-standing case law of the European Court of Human Rights, this kind of membership in professional self-governing associations is treated as being outside of the freedom, outside of the scope of the freedom of association provided by the Convention. But according to the Lithuanian Constitution and according to the case law of the Lithuanian Constitutional Court, it is covered by the freedom of association, but again, relying on case law on the European Court of Human Rights, the Constitutional Court proclaimed that compulsory membership in certain professional self-governing associations is justifiable by the constitutionally important or objective to control certain to control certain professions. And there was the second exception from the rule, then the convention cannot be treated as the source for the interpretation of the constitution. Sometimes it can happen because naturally both the convention and constitution were autonomous instrument of different origin and with autonomous and parallel development as the living instruments. So it could happen that for example, the Constitutional Court and the European Court of Human Rights, we all know, I don't like to go deeper here in this case, but we all know the famous case Paksas versus Lithuania, but simply different courts can make different balance of constitutional and human rights values. So sometimes it could happen, but it's exceptional. And just to continue, I would like to stress here, but again, exceptional nature of convention is demonstrated by the Lithuanian Constitutional Court in its case law while dealing with the situation, where both in starting from 2012 and also repeating in a few times more, the Lithuanian Constitutional Court clearly perceives the situation of inconsistency between convention and constitution as a kind of anomaly that should be removed by, of course, by the means established by the constitution. And in this case, the only measure, the only tool to remove this anomaly or inconsistency between those two important instruments is appropriate amendments to the Constitution. Appropriate amendments of the Constitution. I would like to emphasize one more point that in 2014, in the famous case again on genocide, Lithuanian Constitutional Court stated that there are two ways to remove this anomaly. One of course is to make appropriate constitutional amendments. Second one is to denounce respective international instrument, but the second option is not applicable to the convention, as you all understand, because it would be contrary to the constitution itself. If I may repeat, what kind of open civil society could we have without being a party to such an important and in many ways decisive international instrument? And just to make the conclusion, so as the conclusion, I would like to simply to state that in my opinion, this never-ending maybe debate between constitutionalists and international lawyers, who is superior, is a kind of artificial problem. Sometimes based on irrational stubbornness, maybe to maintain either superiority of the convention or of the superiority of the constitution. But if we share the same values, the same principles, I think we always are capable to find the ways how to solve sometimes inconsistencies, and the constitution itself, it obliges us to act responsibly and not to isolate our country from the European development of human rights. that means to be a part of it, rather than to create obstacles for harmonious development. So thank you very much, and of course I am open to your questions.
Thank you very much, Professor and the President of Lithuanian Constitutional Court, Dainius Žalimas. It was really interesting to see, and actually I'm very glad to hear, even though I know these things, that our Constitutional Court has always been in favor of European Constitution, sorry, not European Convention on Human Rights. So now I would like also to ask every participant to start to think about the questions that we will put for the discussion at the end of this panel. And I also would like to announce that we are making a little change in the panel because we are changing one of the speakers. And now I would like to ask Associate Professor of New York University in Prague, Tamas Latman to present his speech. And Tamas, do you hear us?
Yes, I hear you perfectly. I hope that you hear me as well.
Yes, we do hear you. So please, you are most welcome to speak on very, very interesting topic. Thank you.
Thank you very much for the invitation. It's really great to be here today with all you colleagues and professors and some of the old friends as well, which is always nice. The subject that I have chosen to talk here is more of an issue that currently I would argue that probably would raise more questions than answers. And I believe that these questions are important to all of us, especially from us from the Central and Eastern European region of Europe. The subject that we are going to be covering is something that I believe, especially to our generation, was something very interesting when we were at the age of 14, 15, living the political changes and having some hopes, maybe somebody could say illusions, that some of the problems that we have been growing up learning about, hearing about in politics and in social tensions and everything are going to go away at one point, so that we here in the Central and Eastern European region are going to be able to have to step over some of the problems we are having, including historical tensions and historical and political tensions, with the shadows of nationalism and other things. Now, I think that kind of illusion or idea was going on for some time, but then the answers coming to our way sooner or later has become more realistic, and we had to identify, we had to realize that most of these have only been illusions. But now we have the Strasbourg Court, the European Court of Human Rights, and its practice, which is of course subject to criticism on many levels, and it's always a nice thing to have criticism, even towards a highly prestigious judicial body. I do believe that it's not a problem. It should be okay, as long, of course, as the criticism is based on professional ideas and logical thinking and everything. And I believe that the practice that the European Court and the whole European integration has shown towards these very delicate questions have somewhat been reassuring, but on the other hand, there are some problems, there are some questions that we need to address. So basically, the title of this presentation is the European Court on Human Rights is a proper tool for historic sins, which may seem to be like a bit of a journalistic title, I understand. What do I mean under historic sins? Basically, I would narrow the subject material to sins of violations of human rights that are considered to be violations of human rights with our today's legal mind, with our today's legal standards. And this is interesting and important because we can argue, and as we are going to see, the Strasbourg Court and European integration, other bodies and institutions have come up with the argument that we cannot really employ the same standards to events happened 50, 70 years ago than what we are applying now. And while this is true from a professional aspect, and as we can see, the professional answers were created and were adopted in this slide, the reality, the sometimes painful reality, is that this does not necessarily work when it comes to a broader level of reality, including social realities and politics and everything. And the problem is, and that is a big challenge for the Strasbourg Court, and that is what I plan to analyze a little bit here. Can the Strasbourg Court somehow still meet the needs and the requirements adopted in this dimension, or is it going to sink into a constant level of political debates and criticism because of some of the professional ideas and professional arguments that we are having, and we think that they are correct, are not necessarily applicable in today's political realities. Now, what I mean under historic sins, I mean crimes or violations. I mean violation, I mean the broadest sense of violations of human rights, which have been committed before the time that the European Convention on Human Rights have been adopted or has entered into force. And these violations have been committed by states, by agents of the states or by individuals who have been incited, assisted by states and later be supported, or their possible violations, their possible criminal behavior or behavior leading to human rights violations have been hidden by the state or have been denied from being existing. The problem, as I have indicated already, is that there is a political problem today. We can argue, and we do argue, and personally I do believe that that the societies and individuals living in especially Central Eastern European countries should have already overcome these damages, this kind of sense of victim. And we were hoping that the European integration would give us a possibility to help to overcome these. There have been already questions asked before and during the accession process of the Central and Eastern European countries to the European Union about the possible legal fate of, for example, of the Beneš decrees, which have been adopted in 1945 in the Czechoslovakia, the reading of which today is obviously something that we cannot accept under the human rights domain and the human rights interpretations of today. But of course, legally speaking, when they were adopted, they were a response to a given political situation with under completely different international legal environment. So it does not really make too much sense to try to, from a political approach, to try to employ the same approach today as those political actors at that time did. Now, if you look at the initial interpretations of this problem, for example, by the European Commission or the European Parliament, then we can see that both of these very important basic EU institutions have been trying to get rid of this problem, not to cover them, not to deal with them on the absence. I'm just quoting, for example, the European Commission from March 2002, arguing and stating, for example, that the Commission agrees with the position of the Czech government that the Beneš decrees are obsolete. And there's one point. In 2002, the Czech government was arguing that it's obsolete. This is going to be very interesting a few years later as we are going to go there. And the Commission continues saying that would mean that they do not have to be examined for compatibility with EU law as they have no legal relevance. The European Parliament's very similar interpretation from October 2002 reads, and basically I'm just concluding it, it was arguing that, for example, the Beneš decrees doesn't have any legal relevance here and now because they do not raise an issue under EU law which has no retroactive effect. The decrees, the Beneš decrees, especially one on citizenship, are outside the competence of the European Union. The Czech system of restitution goes on the European Parliament's professional material prepared by prestigious professors by the request of the European Parliament. The report continues going on. The Czech system of restitution, although in some respects discriminatory, as held by the UN Human Rights Committee, so there's a correct reference to earlier international readings, does not raise an issue under EU law. Now that means that we can see clearly that the European Union was trying to get rid of this problem well in advance. So now the problem is, can the European Union really get rid of the problem? And the problem is, the answer is that no, it can't, because, and the reason of this is the European Union as such is an integration form which has a very strong and vivid political aspect in itself, most importantly being, for example, as the members of the European Parliament are directly elected by the European citizens, this question cannot be just forgotten because the voters are just bringing it up. And you know how it happens in politics, including European politics, all kinds of politics. If the voters are bringing something up, then politicians want to get engaged with that problem. They want to be the ones seen providing a solution to that problem. So whatever the idea was from the European Commission, for example, which is a much more of a technical body than a political body in these very delicate subjects. They just wanted to try to get rid of it, but it did not really work. There was a constant political pressure within the European Union after the accession of these states, and we cannot really identify one or two responsible actors for this. What we need to understand is that, for example, the question of Beneš decrees, which has led to massive violations of human rights at that time, the Beneš decrees question has raised not only concerns from Germans or Hungarians who have been the victims of these legislation products, but also it has come into very serious political picture in the year 2009, when the ratification of the Lisbon Treaty was seemingly seriously be put to jeopardy by then Czech President Václav Klaus, arguing that he is refusing to ratify the Lisbon Treaty because they would endanger the applicability of the Beneš decrees. Now, of course, that was a political stunt, and at the end of the day, it did not really work out. And the Czech Republic, luckily, has ratified the Beneš decrees, has ratified the Lisbon Treaty. And I would just draw your attention to the fact that the same Václav Klaus was a member of the Czech government when the Czech Republic had ratified the European Convention on Human Rights, which would actually be really problematic to the Beneš decrees. But then Minister Václav Klaus had no problems with the European Convention at that time. And that is basically showing us how this question is played as a political card by all possible political actors. It's not only the problem of the one-time victims, but it can be made to subject of political debates and political ambitions. And as we could see on the case of Václav Klaus, it was. So because of this political situation, and then there were European citizens' initiatives, petitions filed to the European Parliament, mostly from people from Hungary and other countries who were victims. The European Commission had to react to these issues and to these initiatives with trying to get a distance from the problem. And basically, the European Commission has never said anything else than it has said from the very beginning, arguing that this is out of the scope of the European Union. If ever it was applied by any EU member state, then the Strasbourg Court would come up and could come up and protect the needed human rights that could have been or would have been violated. But I believe that nobody really has taken it seriously that could ever happen. So basically, the question has already been started to be pushed towards the European Convention on Human Rights. Correctly so, I would argue, because the European Commission definitely did not want to go into politics and definitely not into historical political tensions. So the EU institutions have started to push the problem away. So then it has started to go towards the Strasbourg Court. Now, it was not only, now the problem with the Strasbourg Court possible proceedings, as you all know who are here, is that the cases are possible if there are individual victims and violations identified. Now, more of these, for example, the Beneš decrees, etc., are very hard to find individual victims, especially because the act itself, the action itself has happened before the European Convention has entered into force. So on paper and theoretically, it cannot cover that subject. Basically, that was one of the strongest arguments of the European Commission all the time, arguing that it all happened before the European Union. Now, absurdity, somewhat absurdly, the cases which have gone to the Strasbourg Court with actions and behaviors and violations or crimes committed at the beginning were much more individuals who could not be qualified as victims, but rather like persons individually responsible for actions. Just to name maybe two of the most important cases, according to my interpretation here, the Kononov versus Latvia case or the Korbeli versus Hungary case. Both of these cases have gone to Strasbourg by those individuals whose sins and crimes were to be put to subject of a member state jurisdiction. And what we can learn from these cases legally is that if the applicable international legal provisions are clear, then the case itself is more clear. It's like the Strasbourg court has an easier job to handle these cases. The big difference between Kononov and Korbeli was on the aspect of applicable law, is that the crimes of Kononov have been committed in the framework of an international armed conflict, while the crimes of Korbeli, which was a case related to the 1956 Hungarian Revolution, the crimes of Korbeli were committed in a situation which was not clearly an international armed conflict, as all the colleagues working on international humanitarian law, the applicable law is different, and as a result of which the interpretations of the Strasbourg court had to be different as well. Of course, we don't have the time, but I believe that the Korbeli case in itself only would require a specific presentation of all the hardships that the Strasbourg court has encountered, meaning with one of the problems, for example, the complete inappropriate nature and unprofessional nature of the applicable Hungarian legal provisions applicable to that situation. Now there is a political thing to learn from these cases as well, and that was something very important, that because of the fact of these cases, in the public opinion, the Strasbourg court, the European Court of Human Rights, has started to seriously risk becoming the body who is responsible for protecting the sinners itself, which is definitely a very bad way and definitely not the direction that the Strasbourg court wanted to go. But the problem was that these were the cases that have been brought to the Strasbourg court. Now this has changed in the past, in the last time. There have been some very interesting cases related to the Beneš decrees that have been entertained by the Strasbourg court, and of course they were raising some attention. And I believe when I have seen those cases happening, when I have seen what Slovakia was doing, for example, which led to this case, has, for example, personally put me as well into some kind of doubt about the possibility and the role of the European integration in being capable of reaching the result that we shall ever be able to overcome these historical tensions. And the judgment of the Strasbourg court basically has put some of the hope back to me. And I'm going to finish this presentation with a somewhat optimistic conclusion. I am promising that. So the case that I want to analyze a little bit is the case of Bosic versus Slovakia, which was decided this year's May by the European Court of Human Rights. First of all, I would like to clarify. I would like to make this very clear at the beginning that the Strasbourg court has not made this case, because it could not make this case, specifically about the Beneš decrees as such. This is not a case about the right to property and the protection of property against state arbitrariness. For example, with the Beneš decrees taking away property from ethnic Germans and Hungarians at that time. But at the end of the day, this case may become a case about the right to property. Currently now, it's about a right to fair trial. And the reason is because the Strasbourg court could examine now the situation of the actions of the Slovakian judiciary and some of the relevant authorities. And those who brought the case to the Strasbourg court, of course, the victim and the lawyers, have targeted on what they could and what they should have targeted. Currently now, the ongoing proceeding of the Slovakian authorities. We are going to see if this is ever going to turn to be a right to property case. I really much hope that it's not going to. The case is basically about, originally and historically, there have been a land reform in 1946 in Czechoslovakia. And during this land reform, it was decided that the so-called traitors of the Slovak nation have to be deprived of their property. Of course, that has meant Germans, Hungarians at that time. Now, of course, this was not perfect. It was not perfectly performed. So some individuals got away with their land and they were not confiscated. And the problem was that some of the Slovakian authorities have started these proceedings again. And for example, in 2009, like in this case, in 2009, the Slovakian State Forest Company tried to take away the land, arguing that this land should have been taken away during and by the virtue of the Beneš decrees, which has led to a shocking step from the authorities that practically in 2009, after joining the European Union, after adoption of the European Convention on Human Rights and taking the international legal obligations based on that, a member state of the European Union and of the Council of Europe seemingly reapplies those legal principles and those legal solutions from the past, which currently now we already think, and there is a consensus, there has been a consensus so far about the fact that they are obsolete. Let me just quote from 1995, the Czech Constitutional Court arguing, and I quote again, about the Beneš decrees, this normative act has already fulfilled its purpose and for more than 40 years has not given a legal basis for any legal action and therefore has no constitutive character. Basically, this is the argument with which the Czech Republic and Slovakia during the European Union, they have always been able to fend off any criticism and legal attack because of the Beneš decrees. And after 2009, taking it again, using it, applying it against an individual is definitely a problem. Now, the Strasbourg court in this May has found it not being in conformity with the European Convention, some of the procedural steps that have been made in the Slovakian jurisdiction, but all these jurisdictional steps were and are showing towards, at the end of the day, really taking the property away. Now, after this May judgment, the Slovakian state has not really responded yet to it, but it's obvious that if they go on with the procedure that was now found to being problematic by the court, the victim and their lawyer and his lawyers are going to take this case to the Strasbourg court once again, which means that the Strasbourg court will be able to really put a legal analysis on today's applicability of the Beneš decrees. And I do believe that if that happens, that I'm pretty sure that the Strasbourg court is going to argue that it's going to be in contradiction to the European Convention on Human Rights. So basically, Slovakia now has the chance to avoid this very delicate problem. And I do believe that is, with a political rationale behind it, that is what they are going to do. And this leads to the conclusion. There is another case, a brand new case by Liechtenstein against the Czech Republic, also based on the problems from the Beneš decrees that has just gone to the register right now. So that is still going to bring up some arguments, I believe. But for reasons that I don't want to get into here because I want to save the time, I think that that's not going to be the same thing. And that case has already had its own long story with other judicial bodies as well. So the question, revisiting the title of this presentation, can the Strasbourg court offer a remedy for sins of the past? My simple answer to this is mainly not, because of the well-established arguments of the time and everything that we well understand. And I need to add, concluding from the earlier Strasbourg court judgments from other individual complaints related to the Liechtenstein case, that seemingly the Strasbourg court does not even have the ambition on this. Mostly because the Strasbourg court doesn't really want to get into politics, really doesn't want to get into political elements of these, I repeat, very delicate and very problematic cases. But still, you may argue, and I may argue, that the Strasbourg court is not an obvious tool and for the remedy of these historical sins, we can argue, and I believe that that is where my optimism is coming into the picture, that the Strasbourg Court is a good tool, is a capable tool of keeping the states from repeating these historical mistakes or sins. When the European Convention on Human Rights was adopted, and especially when the European Court of Human Rights have been created and got those vast powers that it has, that was a very progressive, that was a very enlightened legal solution to make sure that human rights violations, well, of course, they are always going to be human rights violations, but at least they may not be intentional, they may not be systematic, etc., etc. Now, this kind of progressive, enlightened legal tools and legal approach requires the same progressive and enlightened political approach as well, which I believe that that is the point where we need to learn. We need to learn a lot. Politicians have to learn a lot on this. So the point is that states today should not apply these old legal rules. And if they try to do it, the Strasbourg Court may become one of the first, one of the most important body to stop them from doing it in, for example, in cases and situations which otherwise do not belong, for example, into the jurisdiction or the competence of the European Union. So at the end of this presentation, I would just like to quote a commentator on this, who has put it very simple, and I believe that it's his conclusion is very good on this. And I quote, "The Beneš decrees cannot be resolved somehow. The only way to resolve the issue is to forget about it. That means to produce a common declaration like the recent Czech-German declaration stipulating, and that's the point, that the problems of the past should not burden the present and the future." Of course, to be able to achieve this, we need political actors and we need individuals and opinion-forming individuals who would refrain themselves from, for example, nationalism, chauvinism in today's European politics. And if we can do it, then our progressive and enlightened political and legal solutions may be able to work and to keep us from repeating the mistakes that our ancestors have been committing at one point. Thank you very much for your attention, and I'm waiting for your questions and comments. Thank you.
Thank you very much, Professor Latman. It really was very interesting to hear the perspective from Central European countries, because indeed we all have certain historical grievances that we would like also to pass over to international institutions. So I guess during the discussion we will have a chance to debate this issue as well. And again, I would like to ask all participants, think of the questions, because not much time left to our discussion. And I also would like to thank very much Professor Latman for his capability to present his speech earlier than in the program. We had some problems with this. Now I would like to ask to give the floor to Olena Petsun from the Office of the Commissioner for Human Rights, Council of Europe. Olena, do you hear us?
Yes, I do.
Okay, thank you very much. So a tricky thing, actually, you will speak about the impact of the COVID-19, and I'm just recently isolating myself because I've just had a contact with COVID person. So it's kind of funny thing, at least for me, but I hope that everyone else is well and without any contacts. So now we are very eager to hear Olena's Petsun presentation, and Olena, the floor is yours.
Okay. Thank you very much, and I will try also to show my PowerPoint presentation if possible. Just a second. Okay. Is it working?
Okay. Unfortunately, we don't see it yet. It would be working if you would share the screen with us.
Okay, yeah, that's what I'm trying. Just a second. share. Okay. Sharing.
Yes, now we see the PowerPoint.
You can see it. Okay. So
Yeah, but it's still yes, I guess now
okay.
it's everything okay.
Okay, thank you very much. It's a real pleasure for me to take part in this conference as a representative of the Office of the Council of Europe Commissioner for Human Rights. And the topic of my presentation indeed is related
Olena, you have switched off the sound of yours, so we don't hear you.
Okay. Does it work now?
Yes, it's working.
And you can hear me, right?
Yes, we can hear you.
Okay. Okay.
So let's start again. Sorry.
Yes, I hope that now it will work. So it is a real pleasure for me to take part in the conference as a representative of the Office of the Council of Europe Commissioner for Human Rights. And as you rightly pointed out, the topic of my presentation today will be related to the role of the Council of Europe Commissioner for Human Rights in promoting human rights during the COVID-19 pandemic, which unfortunately it's still present with us here in Europe, also globally. Some people continue to talk about, the second. I mean, many believe we are now in the second wave. So the Commission from the outset has been monitoring this situation, and in my presentation, I will talk about different findings, lessons learned, and also some reflections about what it means for the human rights, what are the consequences for the future. So just to tell very briefly that the Office of the Commissioner for Human Rights is an independent, non-judicial institution established in 1999 to promote awareness of and for human rights in the member states of the Council of Europe. And the activities of this institution basically focus on three main interrelated areas: country visits and dialogue with national authorities and civil society, thematic reporting, and advising on human rights systematic implementation and awareness raising activities. So these are the main activities, and the Commissioner is elected by the Parliamentary Assembly of the Council of Europe for a non-renewable term of 6 years, and the current post holder, Dunja Mijatović, took up her position on the 1st of April 2018. The important part of the Commissioner's mandate is related to, of course, since we talked today about the European Convention on Human Rights, so the Commission is fostering the effective observance of human rights and assisting member states in the implementation of all Council of Europe human rights standards, but notably she has a very important role in addressing any existing shortcomings at the national level in the implementation of the European Convention on Human Rights. The Commissioner also has the right to intervene as a third party in the proceedings of the European Court of Human Rights, either by submitting written information or taking part in its hearings. So it has been from the outset of the COVID-19 pandemic, the Commissioner has been monitoring different measures which were taken by the governments in the Council of Europe member states to contain the spread of the virus and the risks that some of these measures may pose to human rights. This health crisis has not only, in our opinion, exacerbated long-standing problems and exposed the already existing gaps and weaknesses in the human rights protection systems at the national and European levels. However, it has also revealed their strengths and urged us to rethink our priorities. And there are also important lessons to learn and opportunities to shape a better future. The pandemic, and some of the speakers in different panels talk about this specific impact of pandemic on different groups, but that was our main conclusion from the beginning, that the pandemic has had in particular drastic impact on the human rights of people whose rights were already largely neglected before the pandemic. And this includes older persons, persons with disabilities, women, children, Roma, detainees, migrants, LGBTI people, and media professionals. And since like beginning of March, that's approximately, actually in France, the lockdown started in mid-March, and in many other states it is a little bit earlier or then a little bit later. So since mid-March, the Commission has made a number of different statements and published human rights comments and opinions related on how to address these new challenges, unprecedented challenges in a human rights compliant manner, and also how to avoid to impose unnecessary restrictions on the enjoyment of human rights by different groups of people. And here I'm just, I have a list of different statements and other publications made by the Commissioner. By the way, all of these publications are available on the Commissioner's website, and we now have a separate thematic page devoted to COVID-19 crisis. One of the major lessons I think that we may draw from this pandemic is that we need more equality. So this is the lessons learned. It was clear that this health crisis has a broad impact on the right to health, on the economic and social rights, and of course on civil and political freedoms. In a way, it also has an impact on the very social nature of human beings. The right to health had obviously come into the focus of everyone's attention during the pandemic, and the Commissioner has emphasized throughout her publication and speeches and other activities that the universal and affordable health coverage provides a solid basis in guaranteeing this right. But a broader social rights approach is necessary to address entrenched health inequalities, including through eradication of homelessness and by addressing housing issues and access to employment. The health crisis has also deepened the already existing gender inequalities and increased women's exposure to gender-based violence, in particular domestic and sexual violence. As the governments have been taking certain measures to mitigate the negative effects of the crisis on women's rights, the Commissioner was urging them also to ensure that women's sexual and reproductive health and rights are not overlooked or neglected. As we all know, unfortunately, the pandemic has caused numerous deaths throughout Europe among older persons, and confinement measures continue to have a strong impact on their social lives and mental health. There is still a continuing need to provide support to all the persons and prepare for the implementation of the overdue social care reforms in many member states, which would put the human dignity at the center. It is equally essential to ensure the continuity and safety of the services required by persons with disabilities, including by ensuring adequate protection of social workers and addressing the particularly worrying situation in residential institutions, where, as we know, there have been numerous reports about the outbreak of the COVID-19. Due to the high risk of transmission of the virus among those in prisons, The Commission has also urged member states to use all available alternatives to detention whenever possible and without discrimination, as well as to review the situation of immigration detainees. She also stressed the importance of safe disembarkation of migrants rescued at sea. Another issue of concern was the living conditions and access to water and sanitation for Roma, and the provision of emergency accommodation and long-term housing for homeless people. The LGBTI people have been facing increased levels of domestic violence, homelessness, poverty, and harassment risks in the context of curfews and restrictions of movements. There has been a lot of misinformation and disinformation circulating about COVID-19, some of which could have caused panic or social unrest, or have other harmful consequences, such as racist and xenophobic allegations about people belonging to national minorities or foreigners spreading the disease. The legitimate need to combat disinformation, however, sometimes led governments to introduce measures that risk unduly restricting press freedoms and hampering the work of journalists and media actors, and therefore the public's right to receive information. Another topic that has been largely discussed in several member states was the use of digital devices to help enforce quarantine orders, track the progression of infections, or inform people about their possible exposure to infected individuals. While acknowledging the potential of digital tools to strengthen the ability to contain the spread of COVID-19, the Commission has emphasized that such tools should be introduced only if they are designed and used in a way that ensures data protection. As I said before, it is important to note that the pandemic has not only exposed the weaknesses in the human rights protection system in Europe, but also revealed its most valuable strengths. First and foremost, citizens' interest in and probably also awareness of human rights has increased after they have experienced what it means to have their freedoms restricted. The national human rights institutions, ombudsman offices, and equality bodies, as well as their networks, have stepped up their efforts to protect human rights during pandemic in a variety of ways. Since the beginning of the pandemic, the Commission has encouraged all member states to listen to their advice and recommendations and to ensure a human rights compliant response to the pandemic. Well, we all hope that the vaccine and drugs to limit the impact and spread of the coronavirus will become available sooner rather than later, and our life will return to a new normal. In the meantime, many governments throughout the Council of Europe are taking important steps towards easing, or in some cases even completely abolishing, the restrictions which have been put in place to contain the spread of the virus. It is important to ensure that any restrictions which were imposed due to this emergency are in place for the shortest period of time. And what is even more important, that these restrictions are not eventually transposed into the ordinary law, as we have been witnessing in the past with other emergency measures adopted in some member states. The pandemic will likely have important short-term and long-term consequences, including yet another economic crisis with its social repercussions, which need to be addressed in a way that would not exacerbate the already negative impact of the current crisis on human rights. It is important to find the courage and the foresight to strengthen the place human rights occupies in our societies. We should start by giving a more central focus to the equal enjoyment of social and economic rights. Furthermore, young people whose opportunities for work and study being hit very hard during this crisis will require special attention in any recovery effort. One crucial way in which negative impact on vulnerable groups can be mitigated is by listening to their concerns. The governments must work with civil society groups and address the real needs of the people, which are also reflected in the relevant legal standards. In many instances, being able to harness the expertise and goodwill present in civil society can go a long way. Another important instruments we should keep in mind in this regard are national human rights strategies and action plans. And the experience of different Council of Europe member states which have adopted such strategies demonstrate that they are an effective and flexible tool for addressing a broad range of human rights concerns in a coherent way. They are useful for assigning responsibilities and identifying gaps in human rights protection. It is important to ensure an inclusive and participatory approach towards their development, implementation, monitoring, and evaluation. And this is essential for improving human rights protection at the national and local levels. So I'll stop here. Thank you very much. And if you have any questions, I would be happy to answer them. And I wish you a very fruitful discussion. Thank you.
Okay, thank you, Alena, very much for your presentation. For a moment, just one moment, we're having some technical difficulties, but
okay.
Okay, yeah, okay.
Okay.
Okay, you have stopped your screen. So
yeah.
So great. So thanks again for the presentation, and thanks for all the distinguished panelists. And now we have time for the discussion. So I'd like everyone who would like to pose a question for the panelists. They are most welcome now to raise their hands or whatever is done on the Zoom, and we'll give the floor for the questions, and we will gather some questions, and then we'll ask panelists to answer. So please, now the floor is open for the questions.
I see the question in the Zoom group chat. So if I can read that question. It's a question from Zuzana. A question to all distinguished speakers. What is your opinion about the attack on women's human rights happening right now in almost all EU countries? That became even more evident during the pandemic. Violence against women, double shift at home, childcare, reproductive rights, pay gap, representation, and lack of women in decision-making. What you, as the experts of your fields or your organizations, do or can do better to improve half of the population's, example, women's lives, by preventing constant breach of their human rights? So the question. Thank you.
So yes, please. Yes, Tamas, please, what are your opinion on this?
All right, thank you very much for the question. I would just like to give you my opinion and my experience on that. As you know, I'm from Hungary, and the Hungarian government is one of the governments now currently in the Council of Europe and the European Union, which resists ratifying, for example, the Istanbul Convention, for all kind of made-up political reasons, which are basically the origins of which can be found in PR, not on actual substantial ideas behind that. I think that what is a very important thing to do to those individuals who have access to certain amount of public, including people like going to the media as invited experts on these fields. I believe that one of the most important thing that our job is, and what we are responsible to do, is somewhat an awareness raising, and somehow to take on the political demagogy, the populism that is coming from certain political circles and certain political actors. And then by politicians in office who are decision makers, etc., they shall be doing their job as well. And to help them do their job, our job as academics, individual experts, and everybody, our job is our responsibility is to provide them with expertise. If you want to put it that way, I like to talk about lobbying, even lobbying, which is usually a nasty word, but I think that it's not a nasty word after all. So that is all the job and all the things working as an academic that you can do. Of course, if somebody is actively engaging in NGOs activities, then they have a hell of a lot of other possibilities to do. But also as an academic, personally myself, I like to support the work of NGOs who are specialized on these fields. I think that the problem that could be, if we don't address that problem, is really, if we don't do anything, then it's a serious problem. And even if you are not in 100% agreement with what there is a very vivid discourse on, for example, violence in the family, violence against women, women's rights, feminism, etc. There's a very vivid discussion in which you may all have your opinions. You don't have to agree on everything with everybody. But keeping it silent is just helping those political actors and those individuals who want to work against those goals, even those goals where there is a wide consensus. So I believe that as academics, this is the responsibility and this is the work that we have to do.
Thank you, Tomas. Professor Žalimas, Professor Kūris, would you like to react to this question?
I could say a few words. I'm sorry, I may have not heard properly the beginning of the question. That was about women's rights and so on, yes?
Yes, it's on the chat windows. We can repeat if there is a need.
Anyway, no need, because we already heard an interesting response, and I could only add a couple of things. The question was about what we in our respective fields can do to raise awareness and so on, and to raise these standards, in particular concerning women's rights. Well, I'm a judge, so I cannot set the agenda. The agenda of courts, including this court, is normally determined by those who apply to the court. So it's, of course, for the civil society and for the potential applicants to raise these issues, and then the issues go to the court. But I must say that I see a very progressive development throughout the years in cases, especially in cases pertaining to women's rights, to cases concerning domestic violence, including some cases against Lithuania. There was a landmark case in 2013, right before me starting this job, which was called Valiulienė versus Lithuania. I think one of the landmark decisions on domestic violence. But there are many others. I just suggest for those who want to raise these issues to visit the court's webpage. There are important documents there, documents or files, guides regarding certain problems, or guides regarding certain interpretation and application of certain articles of the convention. And there are several of them, of those guides, which is a synopsis of already existing case law and the main principles that could be further used in various applications. Another venue is, and the court is usually very friendly in this respect, that different NGOs, different non-governmental organizations, national and international actors, they can join cases, and they do join cases as third-party interveners, and they sometimes are very, very useful. I could remember at least several cases where third-party interveners really provided a lot of thought-provoking submissions or considerations on these matters. So to sum up, yes, courts can do a lot, but they have to be triggered. I think that Strasbourg court is no exception. There must be someone who triggers the court. Thank you.
Thank you very much. Professor Žalimas, you also
thank you.
Comments.
Just to add maybe a couple of things, but I think, of course, it's not for the court to set any agenda, but when we do have cases, if I may recall, for example, in 2017, the Constitutional Court got the case, you remember, maybe on one member of the parliament accused of sexual harassment. So even then, the Constitutional Court relied as well, also quoted the Istanbul Convention, although the convention itself still is pending and waiting for ratification, and nobody knows really where there will be sufficient, let's say, political will to ratify it. But what can the Constitutional Court actually do? I think to be sufficiently determined and sufficiently brave in order to disperse, as I mentioned in my report, the widespread stereotypes by formulating according official constitutional doctrine. So I think that the Constitutional Court really can at least deprive populists in politics from using constitution in their argumentation. Because once the Constitutional Court establishes that no discrimination is possible, for example, Istanbul Convention is a sort of progressive standard again, and a minimum constitutional standard in this field, I think it's the most what we can really do in promoting, I'd say, respective constitutional and human rights culture in our country. Thank you.
Thank you very much. While we're waiting for the question, I would be very interested if Professor Kūris could comment on Professor Latman's speech on the historical sins and European Heart of Human Rights. Because I guess that you had already this experience, and what would be your views on the views expressed by Professor Latman?
Thank you very much for the question. I can say a lot and very little at the same time, and I will just I will soon explain why. I really listened with great attention to Professor Latman's presentation, and it was very interesting. One point, among those cases that deal with historical sins, a couple of cases were not mentioned, but I understand that no one can cover all. But in Lithuania, they are perhaps the most well-known. One is Vasiliauskas, where the Grand Chamber decided not in favor of Lithuania. I myself was in that case in the minority, and the minority was 8 against 9. A very controversial judgment. And then there was a chamber judgment, 5-2 judgment, Drėlingas versus Lithuania, where the chamber decided that Lithuanian authorities, including the top courts, that they made a necessary conclusions of alleged mistakes that were committed in Vasiliauskas' case. So those cases could also be added to the picture. And I believe there are so many other cases of Krenz from Eastern Germany and so on. So there are so many various diverse historic grievances that come to the court. Or you take cases like Perinček or other cases about Armenian genocide. They concern events that were even much older than the Hungarian Revolution of '56 or a post-war period or so on. So that is a very interesting topic, and I believe that there will be all sorts of diverging opinions, and Justinas Žilinskas himself has written a couple of articles I read on Lithuanian cases in Strasbourg, yes, about the genocide, the concept of genocide in Lithuanian case law and Strasbourg case law. But what was even more interesting for me in Professor Tamas Latman's presentation, and I really had my both ears, directed to him, was this discussion about the upcoming case, the new application in an interstate case of Liechtenstein against the Czech Republic. This is very interesting. There were so many people who said that the Beneš decree issues in that form, especially the Liechtenstein property, former Liechtenstein property in the Czech Republic, that these cases may not come to Strasbourg because of ratione tempore considerations. But now we had this decision of the court, I believe in Brno, which triggered and which gave the opportunity for Liechtenstein to initiate that case. And I have some views on that, but please understand me correctly. As of perhaps the 1st of October next year, this year, which is in a couple of weeks, we have a new reshuffling, partial reshuffling of compositions of sections. It happens once in a while. I already went through a couple of them. This time I will remain in the same section, but there are two other members of the court who are coming to our section, unless there will be any changes. One of them is the Czech judge, and another is judge elected in respect of Liechtenstein. It's just a coincidence. It was decided before the application came in, but it's very likely that the case will be before the section of which I'm a part of. So I really cannot pronounce anything more. I just want to say that I really was listening very much to very attentively to Professor Latvan, and I will be very happy to discuss these issues sometime in future, but I cannot discuss them in this forum. But there is one important point I wanted to make on this subject. I really can follow and agree the reasoning that the Strasbourg court may be a very useful, efficient instrument for the states, that they don't repeat their mistakes in the future. Not only their mistakes, but mistakes of other countries. And for example, Beneš decrees, this is a piece of old legislation from which the Czech Republic, or maybe Czechia and Slovakia together, can draw conclusions, but also other states can make their conclusions. And of course, the Strasbourg court can facilitate such developments for the future. So states don't commit something which may give rise to new litigation in the future. And in that case, human rights, or at least alleged human rights, may be prevented. The tricky point is that usually those who apply to the courts, not only Strasbourg courts, but any court, they apply not because they want some problem to be settled in the future, for the sake of posteriority, for the sake of other people who will maybe facing similar problems and may find themselves in similar situations. They want their own personal grievances to be addressed. And when it comes to Beneš decrees or anything like that, I believe that the applicants in these cases, they may not care too much about the future. They care about their interest, and the court has to decide their case. So even if the court may say, or the commentators may say, that the court will be very good because it will address the problem, and then everybody will know what should be done in the future, still the opponents of this approach can say, yes, but that's not enough. The court simply cannot escape certain problems, certain issues, even if they are not comfortable. Just yesterday, we had a deliberations in a Grand Chamber case, a case where a big unanimity, I cannot reveal more now, but where a great unanimity was on the major subject. But there were some side subjects or side elements on which the positions of the court were divided. And some of the judges said, okay, for the future, this a judgment as a declaratory judgment. There is a term in the court's case law that court's judgments are declaratory. Sometimes the court says that openly. As a declaratory judgment, it will have significance for future practice. However, the applicants in this case, they don't come here for doing some for the future. They come because they have their concrete grievances. So has perhaps the family in Liechtenstein, so has perhaps those who applied in Korbeli, in Reikveni, in Krenz, in finally Vasiliauskas and Drelingas, and so on. Thank you very much.
Right, if I may react in a few sentences. Hey, Justinas, you have lost your voice.
Oh, okay. Yes, please react. But if you can, please shortly, because we are running short of time. So I'm really sorry, but indeed.
I would just like to add two comments, and while I wholeheartedly agree with everything basically that I have heard. When it comes to individual interests of applicants in front of the Strasbourg court, it tends and it happens to be in contrary with community interests or or they may also serve political interests, not necessarily of the individual complaining individual, but also to, for example, the lawyer that is representing the given victim of the possible violation. I think that, Your Honor, a judge, you have already seen things like that when a case is partly about even the lawyer who is representing the case. So of course it's always a problem. But what is very important, I believe, and what you have also mentioned, I do think that the courts, especially the Strasbourg court and its judgments, even if they can be debated or argued, but it has an educative effect or a warning effect, especially to countries which want to, for example, join, for example, the European Union. I just come into my mind a few years ago when members of the Serbian parliament, Hungarian ethnic origin members of the European Parliament, have come to me a few years ago because the Serbian government wanted to introduce a restitution law which would have been discriminative against these Hungarians from historical era. And what I wanted, and what I was helping with them, that we were immediately drafting up some documents, and they could show it to the Serbian government that if you introduce this law to the parliament, we may go to the Strasbourg court. And obviously at that time, the Serbian government was deterred from introducing that law because they did not want to take the political risk. And of course, they were calculating with the possibility of joining the European Union sooner or later. So they did not need that. And that is a way that I believe that even using good elements from politics, you can be able to achieve some good things when it comes to protection of certain values and human rights. And the court, every court is very important for that. So I would just wanted to add this to the thoughts that we have heard. Thank you very much.
Thank you very much, Tamás. And now there is one more question from Laima Weige. Laima, do you hear us? And Laima?
Hear you, but can you hear me?
Yes, we can hear you. So please, please put your question. And unfortunately, this will be the last question that we can accept in this session because time really runs very quickly. So Laima, you are most welcome.
Yes, well, thank you very much for brilliant presentations and very smooth organizing of the conference. I wanted to say that I'm going to have a presentation on women's rights during the current crisis, if someone is interested in the afternoon. But now I have a question about the concept of the family, probably to Professor Žalimas. So you have already mentioned that in 2011 and 2019, there were a couple of Constitutional Court rulings on the concept of the family. And if I understand correctly, these rulings of the Constitutional Court require active legislation by the Parliament, which, however, has not happened so far. On the opposite, there was a new law enacted in 2017 that connects the concept of the family to gender complementarity, so that men and women compete each other, and that is considered the most natural family for raising a child. So if I may say that it seems that two different ideas of national identity emerge between the legislature and the Constitutional Court. And what's next? What is going to happen? Yeah, that's all.
If I may, yes?
Yes.
Okay, thank you for this interesting question, but you know, I am not representing the legislator. So no. I cannot say what laws should be or not be amended, but under the Constitution, and it's a part of national identity, because what is national constitutional identity? It's the exclusive role belongs to the Constitutional Court to describe. Very simply one difference between two different institutes. They are interrelated, but also different. Between marriage, you know how marriage is defined under the Constitution. In order to change this definition, you need the constitutional amendments that was also proclaimed by the Constitutional Court. But between family can be established not only on the basis of marriage. And what necessary steps should be taken here, you know, yourself, I think, that there is not a working institute of partnership, for example, but it's the sphere of competence of a legislator. For the Constitutional Court, it is clearly established that it is family is gender neutral, and therefore there is no constitutional basis to discriminate between same sex couples and different sex couples in the family relationship. And of course, let's say necessary legislation should be in place, but I am not in the position to comment what precise legislation should be adopted. Thank you.
Okay, thank you very much, Professor Žalimas. So now I would like to conclude this session, and again to extend my and organizers' thanks to Professor Judge Egidijus Kūris, to Professor Judge Dainius Žalimas, to Professor Tamas Latman, to our colleague Olena Petsun. Thank you very much for the participation. I hope that everyone else will stay in the conference and will follow further discussions. And I'm really sorry for Gediminas Sagatys, who asked very interesting question, but we're really short of time and we cannot accept it for a moment, but I hope there will be times to discuss these issues. And again, thank you, and I hope to see you further.
Thank you. Bye.
Thank you for our chair. Unfortunately, we are so short of time that we cannot do a break, so we will start directly with the second part. The chair of the second part is Professor Danutė Jočienė. She's both the judge of the Constitutional Court of the Republic of Lithuania. She's a former judge of the European Court of Human Rights, and she's also a professor in our Institute of International and European Union Law. So I'm giving floor to her.
Hello, everyone. Can you hear me?
Yes, we can perfectly hear you and see you.
Okay, so it's my great pleasure to be with you during the second part of our conference and to see my very known people, very nice people here. And of course, when starting the second part, I also would like to express our gratitude to our director of the Institute of European International and European Union Law of Mykolas Riomeris University Law School, Professor Saulius Katuoka, who was very much supportive, who was supporting us in every step when organizing this conference. And this was not so easy because this conference is going online. So as mentioned by Justinas, we are somewhere in the cyber space. So, and now when starting the first part, I have very big pleasure to present very famous in Europe person, my good and old friend, Ineta Zimele, who has so many titles that it's even very difficult, Ineta, to present you. Ineta is professor of Riga Graduate School of Law. She's former president already of the Constitutional Court of the Republic of Latvia. She's also former president of the section at the European Court of Human Rights. And now just a few days ago, Ineta was appointed to judge in Luxembourg in the Court of Justice. So dear Ineta, it's our, in the name of organizers, we congratulate you a lot with such an important position in EU sphere. And of course, now I give the floor to you to speak about human rights in times of pandemics and the judiciary. So, and you're totally free to discuss judiciary from different angles or from different aspects. Please, Neta.
Ineta, we can't hear you.
Ineta, we are still not hearing you. No. Can you just try once again, because we cannot hear you?
maybe a small suggestion, if you have maybe a MacBook, there should be a permission to have no, okay? So if you have headphones maybe switched to your computer somewhere, so you have to take the headphones then from the computer, because otherwise you will not hear us, or we will not hear you. No.
So let's hope that Ineta will come soon back to us.
I would only also ask that it could be the microphone is in settings is just switched off, the sound of the microphone, because we see that the sound of the computer is on. So probably there's in settings something that we cannot hear.
Yeah, maybe. Dear Ineta, are you coming back to us? Maybe it's time to answer the last question raised by our judge Sagatis now, as we have time. But I think interveners from the first part have already disappeared.
I see Professor Žalimas is ready to answer the question, but Dainius,
okay,
let's see that when Ineta will be able to connect, we will. Okay.
Actually, I would like to be very short. You know, I didn't touch this issue, but actually it is not the only way to remove inconsistency between jurisprudence of Constitutional Court with European Court of Human Rights. There is also one more theoretical possibility so far, that is reinterpretation of the case law of the Constitutional Court. But in that specific case, I mean Paksas case, the Constitutional Court really had the arguments not in favor of reinterpretation, because you know, there are more constitutional values involved in that case, such as impeachment as an institute, such as constitutional oath. I think dear colleague Gediminas Sagatis knows very well. So yes, there is a the third theoretical possibility to reinterpret. And if I may recall, one of the purposes of reinterpretation can be the higher standard of human rights protection, but providing that this does not change all the system of constitutional values. And actually, because in that case, the passive right to be elected to the parliament was related with much broader institute of impeachment and much broader institute of constitutional oath. That was the reason not to reinterpret the case. And in that case, unfortunately, yes, the only possible way is constitutional amendment, but it perhaps in future it could be. I hope it will never be any inconsistency in future, but still the third way is also possible. So I hope that I answered to the question. Thank you.
Thank you very much to the President of the Lithuanian Constitutional Court. And sorry, I did not understand that you want to intervene. I apologize. So we have Ineta is back to us, but we cannot still hear her. Ineta, can you? No. No, we cannot hear you, Ineta. Still. Katarzyna, maybe you can help once again. Like to explain to Ineta what can be the technical problems, why we cannot hear her?
Yeah, so there could be a problem with the microphone. That microphone doesn't have access to Zoom, and then if it's Windows 10, it has to be found through Windows search box microphone privacy, and to switch allow apps to access your microphone toggle and enable Zoom access. So it's I can write in a message what can be done, because this probably something there could be. I already called our IT specialist, and they also told that there could be Microsoft Teams. Yes, in chat, our PhD student wrote how to do this, how to try to unmute the microphone to allow to use that Zoom. If you had used Microsoft Teams, for example, before, it could be that it needs to be switched off, because the Microsoft Teams can have stolen the microphone. So if there will be any other apps also online that are using the microphone, this could be also an issue. So this is something with the allowances and privacy of microphone in the computer itself. If you could see the message in chat, there is a message what can be done quite fast with this in Windows.
Mm-hmm. Well, Ineta is writing, go ahead with the program. I will step in, attend. So maybe I think we can do like this. Now maybe I give the floor to the second speaker, and then Ineta will try to fix all technical problems, and then she will come to us as a second speaker, or maybe at the end of our second part. So in this case, I give the floor to Mr. Christoph Kemp, who is a director and officer in charge of the Office of the Organization for Security and Cooperation in Europe, High Commissioner on National Minorities. And Christoph Kemp will speak to us about minority rights protection during pandemics. So please, Mr. Christoph Kemp, the floor is yours.
Yes, good morning. Can you hear me?
Yes,
of course we can hear you.
But you cannot see me. And when I try to start the video, I'm being informed that you cannot start your video because the host has stopped it. So perhaps the host can.
No, we haven't stopped you at the moment.
Now, yes, there we go.
Okay, now we can see. Okay, please, Mr. Christoph, so the floor is yours.
Yes, thank you very much. And thank you very much for allowing me to speak a bit later due to another online event I was participating in this morning. And I also would like to thank you very much for your invitation to my office to speak and share some of our work. When the COVID-19 pandemic started, and as an institution mandated to provide early warning and early action at the first sign of possible tensions involving national minorities, we were concerned about the potential impact of the pandemic and related measures on diverse societies. And from the experience of successive high commissioners in monitoring trends related to inter-ethnic crisis and conflict, it appeared clear that in times of crises, they tend to accentuate structural inequalities or exacerbate discrimination and even hatred, and as such divide already fragile societies even further. So we felt aware of the risks. Emergency measures to prevent and contain the spread of the virus, as well as longer-term policies to minimize the effects of the crisis, could expose shortcomings in governance and existing structural imbalances. And this could carry security implications, including for diverse societies. So if certain groups in society perceive that they are being treated differently, regardless of whether this is indeed the case, this can undermine trust between communities and existing divisions may deepen, creating an environment in which identity-related matters can be politicized or even securitized. And these risks motivated the then High Commissioner on National Minorities, Lamberto Zanier, to issue a set of policy recommendations under the title Streamlining Diversity, COVID-19 Measures that Support Social Cohesion. And we did so in April, and we shared these with all the 57 participating states of the OSCE. And this advice, which is based on existing guidance of our office and developed by the office in a number of sectoral policy areas, for example, access to media, access to public administration and services, access to education, calls for non-discrimination and inclusivity as driving principles of any response to the crisis. Many countries are now out of the emergency, although it's too soon to tell how things will develop in the next months, but still have to deal with the mainly economic fallouts of the crisis. Some other countries are experiencing significant relapses of the pandemic. And despite these variations, it is clear that COVID-19, although perhaps no longer in its acute phase, is not yet over. And it's important that we reflect on what we have learned from it and inform future policies accordingly. While it may be too early to draw conclusions, let me share some observations. In terms of right to life and right to health, we have taken note of reports suggesting that members of non-majority communities may be exposed to high risks to contract, be hospitalized for, or die from COVID-19 due to their profession, living conditions, limited access to free healthcare in certain countries, and also cultural aspects. It needs, however, to be noted that reports addressing these issues mainly focus on diverse societies in Western Europe and do not cover national minorities as such. While it is reasonable to assume that persons belonging to national minorities face some of the same issues and may therefore also be exposed, more exposed to contracting the virus, there's not really clear evidence of that. And we have looked in a number of countries to collect data on that. Beyond health risks, data, however, suggests that the COVID-19 pandemic may have affected people belonging to national minorities in a disproportionate and distinct manner as compared to individuals belonging to majority communities in a number of specific sectors. For example, in terms of access to information, and while we observed some good examples where central and local authorities disseminated COVID-19 related information and provided vital services in languages other than the state language to keep everybody informed, we do not have evidence that this was happening systematically, and especially in the beginning of the pandemic and in the first weeks of the crisis, information was often only shared in the state language in a number of countries. When it comes to the right of education, as the education system transitions towards distance learning, the need of children with a minority background to receive education in their mother tongue, along with classes in and of the state or official language, may have been overlooked. It was difficult for some countries to adapt quickly to instruction in the mother tongue, also to online instruction in the mother tongue. And at the same time, we did notice also cases in which online and also televised education has been tailored to the needs of all children. And this has been especially the case in those contexts with decentralized education systems. We were particularly concerned about reported instances of intolerance, xenophobia, and ethnic profiling, mainly circulating on social media platforms, whereby members belonging to national minorities have been scapegoated with the accusation of spreading the virus. And I'm aware of several cases in which authorities were able to identify early warning signs of ethnicity-based hatred and address them. But at the same time, the nature and extent of some of the measures and practices to contain the spread of the virus, including by law enforcement, raise questions about their proportionality and relevance to the threat, and suggest that certain groups may have been targeted disproportionately. For example, the Roma, in many contexts, have been particularly vulnerable to this risk. Lockdown measures and border closures have put on a strain on most regions of the OSCE, particularly affecting vulnerable communities, including national minorities, who are often disproportionately located in border areas. They're also disproportionately concentrated in low-skilled labor, and the informal economy and in affecting cross-border areas with related economic activities. And restrictions to movement associated with the lockdown measures and the closing of border crossings between many countries of the OSCE region have translated into difficulties to access markets and workplaces. We also looked into the impact of COVID-19 on minority women, who in many contexts already suffered from double discrimination. Minority women, who are often concentrated in informal sectors, such as domestic work and agriculture, became, due to COVID-19, particularly vulnerable to unemployment, poverty, and marginalization. Increased family-related responsibilities and protection risk linked to the crisis are an additional source of concern. Although it's not always easy to assess their relevance for and impact on minority communities, we also learned that states have, since the start of the crisis, put in place fiscal and budgetary policies aimed at cushioning the socio-economic effects of the pandemic and related measures, including by extending support to small businesses. In addition, bilateral agreements between neighboring countries to alleviate the economic impact of restrictions to movement, which resulted in derogations for residents of border areas, have proven beneficial. And in some sporadic cases, however, socio-economic grievances and heavy lockdown measures, which may have been perceived by certain communities as unbalanced, have amplified resentments against governments, given rise to protests and caused unrest. Protecting the right of everyone in society to access quality healthcare, education, information in an equal and non-discriminatory way is an obligation states are bound to, and the 70th anniversary of the European Convention on Human Rights and Fundamental Freedoms is a reminder of that. However, human rights compliance in the context of COVID-19 is also in the interest of the state, and policies and measures that do not equally address the needs of everyone in society may well become a factor of instability. It is therefore important for us, and as we do so with the OSCE participating states, to reflect on what the crisis had taught us. And if I may conclude on that with my comments, we have seen that the crisis was often a multiplier or an amplifier of the vulnerable position of national minorities in a number of countries. And we will continue to work with the OSCE states, including on organizing webinars on discussing the impact of that in our different thematic areas. Thank you very much. Happy to respond to questions.
Thank you very much, Mr. Christoph Kemp, for your very interesting presentation from different angles. You have touched the minority rights, and I think that during our discussion, you will receive a lot of questions and maybe some provocative questions from our participants. Now we have Ineta Zimele back with us. So Ineta, can you try just to speak?
Do you hear me now by any chance?
Yes. Finally, we hear you. So welcome, dear Ineta. And so I have already presented you to our participants, so the floor is yours now.
Great. But you haven't heard the greetings that I transmitted from my side, and it is absolutely lovely to see you, Danuta. And really, thank you so much for inviting me. And I congratulate Mykolas Romeris University and the Institute on International and European Law for, in fact, finding a way to celebrate the anniversary, which in my mind is a very important anniversary. And yeah, we haven't done much in Latvia because of the evident times. So I'm very happy to participate. And I was sort of trying to listen into the conference, and already, I mean, the entire morning, and now the previous speaker listed the challenges, in fact, to well, of course, to the convention and the convention system, but I would really say to the European architecture, where the certain rights, certain values are placed in the center, such as democracy, rule of law, and human rights. And well, given the fact that the convention with the European Court of Human Rights is in the center of that architecture, at least still in my mind. I think there is the times of pandemics also show the challenges to this one of the central pieces in this architecture. And I think the pandemics also very clearly showed that the European Court of Human Rights also needs to reinvent itself. Although we kind of knew it with the growing sort of number of applications over last 10-15 years, it was very clear that the court needs to continue reinventing itself. But the pandemics has really showed that once again, and I would like to elaborate on that together with the participants of the conference. It is also clear, like the speakers in a previous panel, the judges, Žalimas, and also Kūris mentioned, of course, the court alone cannot reinvent itself. It is the question of the states parties to the convention, and the pandemics clearly showed that we have rather challenging times in front of the governments across Europe, and including the institutions that they have built. And also the previous speaker already, in fact, resorted to that. Now, what I would like to do, sort of going into this subject matter, pandemics as a challenge to the protection of human rights, to also our mechanisms that we have put in place. I would like to elaborate on that, and I would like to share with you the Latvian experience, both of the other constitutional bodies, but also the Constitutional Court, how we dealt about, with the protection of human rights in these very, very challenging times, because as already was pointed out, of course, what the governments did, they were closing down on individual freedoms. There were lots of restrictions on businesses, on assembly. The churches, at least in Latvia, were closed because of the public gatherings were not allowed because of the rule on physical distancing. It is so the society, the people were required to indeed behave in certain way, to contain themselves rather at home, and a number of people, of course, considered that as a restriction of their freedom. I would think all of this experience, and probably the second similar one coming up anytime, and has already arrived in some states, not in Latvia. For the moment, we are doing rather well, actually, in terms of numbers of the infected citizens. They are very low, but still the anticipation is that we might be heading again to a full-scale restriction on individual freedoms. And as we know from the practice experience in other countries, the European democratic human being is really not ready for that. And it is therefore that I have thought, I have reflected on it, and I have written a little piece on it. The pandemics really gave us also an opportunity, in fact, to, it was a thought-provoking experience, and it gave an opportunity to reassess the strengths of our democratic institutions, their working methods, the aims of the democratic institutions, including the judiciary, including both, I would say, European courts. And it did provoke, I thought this, at least in the Latvian discourse, all of the restrictions and the questions, how should we continue functioning as a state in a situation of lockdown, that of course brought to the forefront the very question of European values, and even in such times, how do we continue protecting the values that do form the core of European identity? As far as Latvia is concerned, there was a fairly active debate exactly along these lines, through the perspective of the need to protect democracy, rule of law, division of powers, and human rights. And so, how does it look? How did we do that? You well recall that in some states, people went out on streets to demonstrate. Germany, notably, being displeased with the decisions of the government to restrict their freedoms. We did not have maybe exactly such sort of examples of the position of the society. The society understood very well a common interest to preserve the health of the society. So the interests of the society were taken as the priority. And therefore, the government and the parliament could adopt the relevant legislative, relevant laws that went sort of long way into restricting individual rights. What the Latvian government also considered necessary was to lodge declarations with the Council of Europe and the United Nations informing of the state of emergency, which was introduced from 13 March till 9 June, informing ahead of possible events that there will be restrictions on individual freedoms that are not necessarily foreseen in the Convention or the UN human rights treaties, but it was to be anticipated that there will be these restrictions, and in order to sort of do it in a transparent and rule of law way, the way the Latvian government understood it, it was considered necessary to lodge these declarations. Also, just in case some of the individuals would eventually complain to the Human Rights Court, for example, the Human Rights Court would have to take the state of emergency declaration into account. For example, one of the most controversial, actually that's where the society had some waves going, was the closing down of the churches. And there clearly the freedom of religion for some time, until our churches decided to go on Facebook and video and learned how to carry out their Sunday prayers digitally. For some time there was a problem. Now, the other difficulty that emerged was how is the parliament still capable of functioning? And is it the parliament that adopts those laws within the state of emergency that lead to the restriction of individual rights? We had a moment where one member of the parliament was infected, and the whole parliament had to go into self-isolation. And so the question emerged, how is it really appropriate to delegate such broad powers to the government, where the government would be entitled to have restrictions on human rights? Now, very quickly, in a way, within weeks, the decision was taken that the parliament will continue to work through digital means, with the help of technology, and Latvian parliament was the first one to, in fact, solicit from IT companies the elaboration for them specifically of an e-parliament platform. So our parliament now is capable of working as e-parliament, probably one of the few in the world. And that meant that the parliament was going to periodically review the regulations adopted by the government on further restrictions, redistribution of funds, sort of the activities that have to do with the redistribution of taxpayers' monies. The Parliament stayed in control of rather sweeping decisions being taken in the first height of the pandemics. However, I have to tell you that this all was possible because the president of the state called an unprecedented meeting on 23 March, sort of 10 days after the state of emergency, unprecedented meeting of all of the five top state officials representing the three branches of power in the state, the parliament, the executive, and the judiciary, where we are, two of us, the Constitutional Court and the courts of general jurisdiction represented by the Supreme Court. And it was the joint communique adopted by the five highest state officials, which in fact explained the constitutional position of the state institutions in the times of state of emergency, where the primary aim was set that the state should function, especially the judiciary, because the judiciary should continue supervising, controlling the observance of human rights in such a state of emergency, and the parliament too. So there was no way that in Latvia, from the constitution point of view, we would have given we didn't know how long, the powers to the government and reducing the relevance of other branches of power. And so we have a 23 March communique, which is also, I think, an interesting piece for further research in constitutional law and human rights, that is also available in English. It was translated immediately in English. Now, what the Constitutional Court also did, even before the joint communique, we, the judges in the Constitutional Court, we also decided that we should continue with the scheduled cases and scheduled public hearings, but we moved into the digital platform. We were holding public hearings through the special platform where the parties and amicus curiae could join us, and basically we worked, the court moved into the computers. But the advantage was that the whole country could follow, because we're streaming that like you do now on YouTube channel that the court also has. And so the main message was business as usual. We can continue considering cases. In fact, very important cases were decided on social rights in the country. So these combined decisions made it possible that even though there was a really very limited movement of people on the streets, limited gathering possibilities, but the state continued functioning, and the checks and balances were in place at a time when evidently individual rights were going to give way to the interests of the society. Now, this is where I go to the importance of the judiciary, and sort of given various also articles published on immediately during the COVID and immediately after COVID on the lessons learned and how we saw how different institutions and mechanisms reacted. Well, the first thing is it was a test. I think the pandemics was a test as to our ability, will and ability to also preserve a certain degree of normalcy in our democratic societies. And one of the lessons, preliminary lessons that I am very ready to draw is that, and that has been the feedback we have in the Constitutional Court from the Latvian society, that it has been extremely important to see the court all the time in action, to be able to follow the court proceedings on YouTube. That had, during such time, also given some sense of normalcy and some sense of stability and a guarantee that where the balancing of sort of the proportionality of a restriction on human rights, that will be assessed properly and in time. So that's the feedback that the Constitutional Court has actually gotten through the social media. And that tells me that it is very important in such difficult times that the judiciary is visible, and that the judiciary within its competence shows the importance of maintaining of rule of law. Now, what I found difficult was that at the European level, there was a moment of perplexity, of confusion. And that also you saw yesterday, the President of the European Commission also admitted that the pandemics has shown that suddenly Europe could not find a way to work together. And that, at least us in the Constitutional Court, in terms of common European judicial networks, we also felt that. I had, as the President of the Court, I had quite a little other good practices going on at that very moment where I could have gotten the inspiration. So it was what we decided to do that really came from us sort of realizing the situation in the country. And in fact, there was an immediate reaction first from the European Court of Justice, at least in terms of their statements, how they are going to proceed during the times of emergency, how they are going to work. That did give certain inspiration. But what was missing was a sort of a joint, maybe initiating of a joint platform with one or the other European courts, in fact, setting the agenda and taking the temperature across the judiciary in Europe, and sort of sharing maybe the challenges and the possible ideas of and the risks, of course, involved, because there are, when you use technologies as a court in the proceedings, there are also considerable risks. So these are sort of the recent experiences. It's a real experience where across Europe, we were closing down on each other, and we were closing down on individual freedoms. And it is extremely important in my mind to actually take stock of the different reactions and practices that were within a shorter time or longer time installed in different countries. Preliminary, I would say there is certainly a need for, now you see the gaps and how transparent this judicial dialogue actually is in Europe. I mean, when it was needed, it was not there. And we again acted within the boundaries of our separate states, you see. I do believe that that's one very important finding that comes out from pandemics, and that there are a number of professionals in relevant with relevant sort of responsibilities, and I do believe that that has to be addressed, since the second wave is coming, already has arrived in some countries. There is certainly a place for more sort of leading voices at a European level within the available mechanisms that we have built for decades. And suddenly, when we have pandemics, that does not function. Now, that should not happen. And we should, yeah, that's something we can discuss. But you see, when we celebrate 70th anniversary of the European Convention, and it does happen within such challenging times, you immediately see where the weaknesses are, and you immediately appreciate, actually, we have it all. We just need to activate it in a more profound and strong direction. And so that's the recent example that I can share with you. Thank you.
Thank you very much, Daineta, for your excellent presentation and for sharing with us your Latvian experience, which is really very interesting to listen, especially for me as a person coming from Lithuania, because you describe like limitation of individual freedoms problem, emergency situation, declaration problems, and so on, whether quarantine can be quoted to the state of emergency, whether this should be done by the government decision, only by the parliament, and so on. I think we have also this ongoing discussions, legal discussions in Lithuania on all these issues, and you can really find in the legal literature very different positions on this issue. So I think we will come to this point during our discussions, and I hope, Ineta, that you can stay with us for discussion time, okay? So, and now I will move to the third presentation, and I give the floor to Francesco De Santis, who is Associate Professor at the University of Naples, Federico II, Italy. And I would also like to say about Francesco a little bit more, that he was a lawyer in the registry of the European Court of Human Rights from 2011 to 2014. So, dear Francesco, I hope maybe we have seen each other on the corridor or in the cafeteria of the European Court of Human Rights. And also that Francesco De Santis is acting now as an expert of the Council of Europe in different committees and different bodies of the Council of Europe. And Francesco will speak to us about right of individual application to the European Court of Human Rights, achievements and obstacles. So Ineta has already mentioned about some obstacles maybe of the convention system during the pandemics. So you maybe will describe these obstacles from more traditional point of view. Please, dear Francesco De Santis, the floor is yours.
Thank you. Can you hear me properly?
Yes, we hear you properly.
Okay.
We see you also.
Thank you very much, Judge Josiana. And first of all, let me express my gratitude to the organizers, and especially to all my colleague and friend Justinas Žiliškas for this kind invitation. And let me also add that I'm honored to join such an authoritative panel on the occasion of the 17th anniversary of European Convention on Human Rights. So let me first of all, from the outset, to explain why in a conference dedicated to challenges and prospects for the European Convention on Human Rights, I've chosen to focus on the right of individual application. Well, actually, the reason has been already explained by Judge Kuriš. And first of all, let me apologize if I misspell your surnames. Sometimes it's not always easy to do that, to spell them properly. So I was saying why I've chosen the right of individual application, because the agenda of the Strasbourg Court, has been said this morning, is decided by those who apply to the court. Or more traditionally, let's say, it's sufficient to refer to the title of the convention. Title usually refer to it as European Convention on Human Rights, but actually it was born as European Convention for the protection of human rights and fundamental freedoms. So as it is known, the real progress made in the aftermath of the Second World War with the convention was into the originality, was not related to the original nature of the list of civil rights and fundamental freedoms, because they were back to those times almost the same of rights listed in the Universal Declaration of Human Rights, and also already in some national constitutions, as the Italian one. In addition to this, there is a lack of economic and social rights into the original text of the convention, and those were slowly added by following protocols. But if we read the preamble of the convention, we can read that and this is the big achievement, the high contracting parties were resolved to take the first steps for the collective enforcement of certain of the rights stated in the Universal Declaration. So the unique innovation established by what I would call a group of visionary thinkers and illuminated politicians was that of creating a judicial system for the protection of the rights enshrined into the Convention, and the judicial system which can be petitioned by states and above all by individuals. Just to quote here the short part of the speech of Pierre-Henri Teitgen on the occasion before the Assembly of the Council of Europe in 1949. No one can look years into the future and claim to be safe from the threat of totalitarianism. This is why we must act first, and we have to create a conscience that can raise the alarm to the national public opinions. This conscience can only take the form of an international jurisdiction within the Council of Europe. And as we know, in the following 50 years of activity of the Strasbourg Court and of the Strasbourg machinery, the rights of individual application was the real engine of this system for the protection of human rights. So let's, I will give a few minutes to the main achievements which have been done relating to the right of individual application. So first of all, nowadays we have rights of individual application. According to Article 34 of the, let's say, of the text of the Convention as amended by Protocol 11 in 1998, person, NGO, or a group of individuals claiming to be the victim of a violation of the Convention have right of access to the Strasbourg Court. It's not possible to join the Convention without accepting jurisdiction of the court and right of individual application, and this right is unconditioned. It's maybe the case to recall for the youngers that this was not the case at the origin of the system, where individuals had right of individual petition to the European Commission for the protection of human rights, and this right was subjected to an optional declaration made by high contracting parties. Plus, also the jurisdiction of the court was depended on an optional declaration made by contracting parties, and only states and commission could bring the case to the Strasbourg Court till Protocol 9, which entered into force in 1990. And I would also, I think it is the case to recall that other regional systems for the protection of human rights do not have a right of individual application to the court. For instance, this is the case for the Inter-American Court of Human Rights, which have a system quite similar to the old Strasbourg machinery. And it's also the case for the younger African Court of Human and People Rights. So this is an achievement, and it's always the case to recall it. Then what does it mean, right of individual application, and what does it entail? States have, as the court has recalled several times, have to abstain from arbitrary interference in the right of individual application. They have positive obligations to furnish necessary facilities to make possible the proper and effective examination of applications, and especially where the applicant is a vulnerable person. In this regard, I think reference has to be made to a relatively recent case, the Center for Legal Resources on behalf of Valentin Campeanu. Valentin Campeanu was a highly vulnerable person with no next of kin. He was a young Roma with several severe mental disabilities, was infected with HIV, and he spent his entire life in the care of the state authorities, and he died in the hospital as a result of neglect. And following his death was even this Center for Legal Resources, so an NGO, they had just one contact with Valentin Campeanu when he was alive, and then they instituted proceedings at the national level in order to investigate on the reasons behind the death of Valentin Campeanu. And afterwards, they brought the case to the Strasbourg Court. And in this case, the court acknowledged the local standing of the NGO as a de facto representative of Mr. Campeanu, and I quote paragraph 112 of the judgment, notwithstanding the fact that the NGO had no power of attorney to act on his behalf. To find otherwise would amount to preventing such serious allegations of violation of the Convention from being examined at international level, with the risk that the respondent state might escape accountability under the Convention as a result of its own failure to appoint legal representatives to act on his behalf, as it was required under national law. Allowing the respondent states to escape accountability in this manner would not be consistent with the general spirit of the Convention, nor with the high contracting parties' obligation under Article 34 of the Convention, not to hinder in any way the effective exercise of the right to bring an application before the court. And furthermore, third point, right of individual application entails the obligation for the states to ensure its effectiveness. This was the legal basis for the court to affirm the binding nature of interim measures ordered by the court. The interim measures is sought by the applicant, the court said in Mamatoklov and Askarov. The interim measure is sought by the applicant and granted by the court in order to facilitate the effective exercise of the right of individual petition under Article 34 of the Convention, in the sense of preserving the subject matter of the application when that is judged to be at risk of irreparable damage through the acts or omissions of the respondent state. Point 4. What the applicant can obtain as a result of a finding of a violation by the Strasbourg court. Well, first of all, he can receive just satisfaction, but above all, he can expect the government to adopt individual measures to ensure the restriction integrum. We don't have to forget that the right, let's say, the effective exercise of right of individual application is also ensured by the execution of the judgments of the Strasbourg court. And this is quite impressive from the point of view of a national scholar. The judgment of an international court have an impact in the domestic level, and as a result of a finding of a violation of the Strasbourg court, state authorities, they have to act, and even the res judicata can be removed in order to let's say, redress the violation in the framework of reopening proceedings. So, point 5, the Strasbourg court, with reference to the right of access to a court set forth by Article 6, paragraph 1 of the Convention, has affirmed that this right entails the right to enforce the final judgment. I already said something this regard. So the Strasbourg court said that the execution, according to Article 6, paragraph 1 of the Convention, is part of the trial in the wording of this article of the Convention. And can the same be affirmed with reference to the judgments of the Strasbourg court? It is the case to recall that there is a process for supervising the execution, and parties can join this process brought before the Committee of Ministers. And lately, Committee of Ministers was also provided with a kind of light infringement procedure, so possibility to, let's say, highlights the refusal of the state to comply with the obligation arising from a judgment of the Strasbourg court. And this infringement proceeding has been quite effectively shown to be quite effective in the case of Mammadov versus Azerbaijan. But, and let's now turn to weak aspects of the practical implementation of the right of individual application. What happens if the state does not cooperate in the execution process? And this brings us to an exceptional scenario. That your application is manifestly well-founded, but unfortunately, this is already like, it's a repetitive case, and the court has already found violation, the same kind of violation the applicant is bringing before the court in a pilot judgment. It happened once, according to my knowledge, that only once, luckily, that if after a few years the states still do not comply with the pilot judgment, And if tons of application arising from the same structural problem at the origin of the pilot judgment is brought before the Strasbourg court, well, the court can strike out those cases, those well-founded cases, from its list of cases. This is, I'm referring to Burmic and other 12,000 cases struck out by the court. The known post-Ivanov cases struck out by the court list of cases and, let's say, sent to the Committee of Ministers, which on the other end could not process individually those cases because Committee of Ministers, according to Protocol 11, don't have any judicial task anymore. So, but the court decided in this way. Okay, this was most likely an exceptional scenario, so it has not to be exaggerated. But what is, in my point of view, was striking in the reasoning of Burmic, and I quote here the dissenting opinion of 7 judges of the minority, is that such a denial of the right to individual application and to have a judgment or a decision on the basis of an individual assessment granted by the convention was motivated by the bureaucratic reasons, I quote, of easing the burden on the court, end of quote. On the other hand, I would say that sometimes one can have the impression that the applicant is not welcome in Strasbourg, or at least is not welcome anymore. One might assume that with the entry into force of Protocol 14 and the beginning of the so-called Interlaken process, the court adopted a new judicial policy. From those who advocate this new course, they would say finally the Strasbourg court stopped to be an NGO and started to be an international court. So I try to quickly substantiate this doubt I have raised. So first of all, after the entry into force of Protocol 14, so from the year 2010, 2011, we see that more and more the court do not award just satisfaction, even in case of finding of a violation. Well, as a lawyer or as practicing lawyers who are listening at me, you might be aware, you are much aware that the just satisfaction is very important for the applicant. It's actually one of the reasons why he's bringing his case to the Strasbourg court. Or the court awards just satisfaction, but on the basis of very standardized reasons. And in some judgments, Gaione versus Italy, for instance, or other judgments like in post-Ivanov cases, the court say, we are an international court. I am an international court. It's not my task to award a just satisfaction. I give a lump sum and that's it. Third point, in the last 10 years, 94% of applications decided by the Strasbourg court have been declared inadmissible, out of which 80% at least by single judge. And I would like to here to recall to our participants that from 2011 till 2016, single judge decision did not have any reason, or at least the applicant was not provided with a reasoning for the decision of the single judge, which was a huge change of the practice, because the Commission in the old system and the Strasbourg court from 1998 till 2011, they did provide the applicant with the reasoning for its application being declared inadmissible. So quite frankly, and if we check statistics, we can affirm that from 2011 to 2016, when short motivation for single judge has been introduced, and above all from 2012 till 2015, this single judge procedure without reasoning served the purpose of cleaning up the backlog of the court, because we had thousands and thousands and thousands of applications. If we check statistics in those years I mentioned, the productivity of the court was the double as the current one. And in this regard, some authoritative scholars had affirmed that this is not worrying, because actually Article 34 do not entail the right to a reasoned decision by the Strasbourg court. Well, I don't know how this is possible to affirm this, having regard to Article 45 of the Convention. Reasons shall be given for judgments as well as for decisions declaring applications admissible or inadmissible. And there is no exception there for single judge. There is exception made basically in the rules of the court, but not in the text of the Convention. Last but not least, I would like to recall the change of practice of the court carried out in 2014 with the entry into force of the new Rule 47. Before, the applicant could send a letter to the Strasbourg court, then he received a pack with an application form, and he could complete his application. If the applicant had sent an incomplete application form, the registry would have somehow helped him out to complete the application. And so he did not take the risk of losing the right of individual application because he did not fulfill all the requirements set forth by Rule 47. Since January 2014, we came to one extreme to the other. Application form can be sent only using the application. The application can be sent to the Strasbourg court only filling the application form provided, which one can download from the website of the Strasbourg court. And the application is assigned to a judicial body only if it complies with all the requirements set forth in Rule 47. So for instance, if I don't have space to explain properly the facts in that ugly PDF editable, I can integrate with a Word file, but all the necessary information have to fill in 3 pages. So I have 2 pages to state the reason for violation. Yes, I can complete with a Word file, but again, it can be tricky sometimes. Also, experienced lawyer sometimes don't manage to respect Rule 47. If I don't send a document which the registry consider important, then the application is not examined as an application. This means that most likely the applicant will lose his right of individual application. And what I consider also kind of striking, the court was a kind of proud in 2014 of this new change of practice, saying that, look, something like 20% of application failed to comply with the revised rule. So we administratively disposed of them. So which is 1 out of 5. And I'm not sure that this kind of formalistic approach is really something which one should be proud of. And it's still the case. I've been checking the statistics from 2015 till 2019. The percentage is always around 20% of application administratively disposed of for failure of compliance with Rule 47 requirements. So in this second part of presentation, I try to highlight some dark sides of the practical implementation of the right of individual application. And my question is, if this dark side is a result of the achieved constitutional role for the European Court of Human Rights advocated by some authoritative scholars. And if there is all these, let's say, controversial aspects, if they are all required, if like a price which we have to pay in order to ensure the sustainability of the system, or if another way to reconcile this advocated constitutional role for the Strasbourg court with the right of application, individual application, can be found. And so with this question open to your remarks, I thank you for the attention.
Yeah, dear Danuta, we don't hear you.
Danuta, we don't hear you.
Could you send a message to Danuta?
Yes.
Mm-hmm.
Danute, we don't hear you.
Katarzyna, can you help us? Do we have a Professor Antoine Bouillis with us?
Yes, we have, Danute. We just didn't hear you. So we didn't hear the announcement. So probably also Professor Antoine didn't hear the announcement.
Katarzyna, I cannot hear you.
Okay. Okay. Dear Professor, are you here with us? You probably...
Yes.
Yes, okay. So you're welcome with your presentation. We have...
Mr. Antoine Bouillis, we cannot hear you.
We hear him.
I can hear Katarzyna. Yeah,
Yes,
I didn't hear the announcement though from the chair.
Yeah, there are some.
Shall I start?
Yes, please. You are free to start.
Thank you. Good afternoon, everyone, and thank you for the organizers for inviting me. Congratulations to the convention, of course, for 70 years, but also congratulations to Nicolás Romeres University for achieving its 30th anniversary. I cooperated with your university for many years in European projects, so it's a pleasure to join your conference on this topic. And I will start with my presentation to share that on the screen with you. I hope you can see it now. Great. So I will address something which is in a prolongation of Professor De Santis' previous talk, maybe another dark side, but maybe with also some uplifting perspectives. And I will address the role of civil society in the European Convention of Human Rights, which has been there from the very start. So this photo you see here is from 1948, from a not very corona-proof room in The Hague, as you can see, where hundreds of people came together at the so-called Congress of Europe, one of the first federal European moments in the 20th century. And that was not just politicians at the time, but also journalists, people from civil society, academics, and many others. We started this European cooperation from which the European movement was created, which in turn created the Council of Europe, which in turn 2 years later adopted the European Convention, as you all very well know. So at this very start of the convention, there was already a role for civil society, because it was many of these movements who wanted European cooperation that pushed for such a European Fundamental Rights Convention. And to continue in the metaphor of the previous speaker, as if the European Court is kind of an engine and the convention too, then maybe civil society is one of the essential fuels, you could say, for how effective the protection of human rights in Europe can be. And I would argue this happens in all stages of cases coming to Strasbourg. So obviously, even before there is an application of which we heard the many problems that currently occur, civil society organizations, but also human rights defenders do a lot to raise awareness about the convention in all the 47 states. Also by training, by the way, national judges. But of course, primarily here of interest is that they support victims, and they do so quite directly, sometimes by giving legal advice, sometimes by even acting as official legal counsels of people applying to the Strasbourg court. And therefore they play a big role in bringing important cases to the court of people who otherwise would maybe not even have known that this is an opportunity for a remedy that exists, or who even have not heard of the European Convention at all. So there's quite an important role already for civil society at the entrance gate, you could say, of the European Court. And then secondly, during proceedings, there's an important role as well, potentially, although this is not happening obviously in every case, and that is the well-known option of third-party interventions, especially in the more mediatized cases. Article 36 offers this opportunity for third parties to intervene. And as you know, not only states do so, but also very often civil society organizations when given leave by the court to do so. And there they play an important role of informing the court of domestic situations, of national context, sometimes of comparative law issues, always, of course, arguing for one side of the other, but also really providing this kind of information input, which helps to enrich the judicial decision-making. And finally, also at the exit, if you want, of the court, the civil society actors can play an important role. Most recently, in the supervision of judgment by the Committee of Ministers of the Council of Europe through the so-called Rule 9 submissions, which are in a way similar to third-party interventions, but then concerning the execution stage of judgments. There again, NGOs can give input on the extent to which domestic states implement or do not implement a certain judgment and give context, and this time not to the judges, but to the diplomats who decide on the supervision of cases. And another very important, crucial role, I would say, they make sure that these judgments get known in the national jurisdictions, not just among circles of lawyers there as well, but more broadly. So judgments of the court, as you well know, in all of our countries, are used for advocacy and also for mobilization around certain issues. An important Grand Chamber judgment can be a push to mobilize people around change of policy at the domestic level. For example, against domestic violence, one of the issues which was mentioned in one of the earlier questions today. So at all stages, there is quite a crucial role for civil society in how the convention and the court can do their important work. And the other way around, there is an important link as well, because civil society itself is obviously protected by the convention, sometimes as an applicant itself, a human rights defender, or also quite often in cases, civil society organizations themselves will complain about fines they have received, or when they are being disbanded or even prohibited, have often turned to the Strasbourg court. And there are a number of very specific rights which are crucial for civil society included in the convention, ranging from freedom of expression to freedom of assembly, of which you can see an example on the photo, which is a cardboard one-person protest in times of Corona in the Russian Federation, where protests, like in many countries, were prohibited, already difficult before the pandemic, but prohibited during. And that led to one-person protests, and one of them, Ilya Azar, when doing so, was arrested in May this year, and then others took up his cause and started to place cardboard depictions of him as a one-person protester and put that everywhere in the street in big cities in Russia. Now, I don't know if a cardboard can apply to Strasbourg, but certainly the actual person could, and that was arrested. So freedom of assembly, also an important right, and freedom of association, obviously of interest for civil society organizations, NGOs. And then next to that, non-discrimination, and especially the right to an effective remedy, are also very important rights from the Convention for Civil Society. Now, substantively from the court's case law, civil society as such has been given additional protection, basically through the line of argumentation of having a role in democracy, which is, as the preamble states of the convention and a lot of the case law, a foundation of the European Convention, and vice versa. Fundamental human rights protection support democracy. And for civil society, two different roles which are connected have been become evident from the court's judgments. One is civil society as a provider of information to the general public, and in doing so, having a right to access state-held information. For example, in the case of Magyar Helsinki Bizottság, which is the Hungarian Helsinki Committee versus Hungary in 2016. So this role of conduit of information, which is a bit similar to the press. And secondly, a role of a watchdog of state institutions or other important actors, again, which originally came from case law on the media, but was extended to civil society organizations for the first time in 2004 in a case against Latvia. So there is a clear additional layer of protection for civil society actors coming from the convention, which is quite crucial for the work of many actors in civil society. However, there is a problem, and of course there have always been violations of rights of civil society actors, but the last 10 to 15 years, there has been a more structural attack on civil society globally, but also in Europe, often defined as the problem of civic space under attack or shrinking civic space. Here you see an example of a director of a local branch of the Russian NGO Memorial, Oyub Titiev, who was arrested on probably fabricated charges of having drugs in his car, but in reality, probably because he was speaking out against the authorities' human rights violations in Chechnya. This is just one example of civic space, the room to for citizens, for civil society to speak out on issues, to access information, to associate, to organize, to participate in decision-making, that has come under pressure, not just in the example I mentioned here, but in many countries in the Council of Europe. And this happens in three different ways. It happens on a very formal level. State institutions have set new laws in many countries, making it more difficult for civil society organizations to form, to register, more controls on their work, on their activities. Sometimes certain activities are forbidden. There are now Council of Europe countries where, for example, the helping of migrants is forbidden for NGOs. So there even criminal law comes in. So there's an increase of that generally. Secondly, we also see that the way in which civil society is talked about by officials, but also on social media, has become more negative. So there's a trend also of stigmatization of human rights defenders and NGOs, for example, as being spies for foreign powers or being helpers of cosmopolitan capitalists, or just for not standing for the people's rights, etc. So it's quite a negative discourse also. And thirdly, it also affects the real room, the practical room for civil society to work. And that has happened also in many cases that have come to Strasbourg, that human rights defenders have been threatened with violence, or in a more nice way, sometimes they have been bought out of civil society by governments just by being offered jobs so that they would become part of state institutions rather than criticize them, which is called co-optation. So different tactics are employed, but they all affect the freedom for civil society to operate. And governments learn from each other, what we could call almost lateral learning, horizontal learning. They copy each other's laws, each other's tactics. Sometimes they literally translate the laws used by neighboring countries. Now, this obviously links to human rights because this shrinking space has as an object those crucial civil society actors that are affected, that are working on human rights promotion. They are much more affected by this than a civil society organization of players of chess or golf. It also relates to the subject of what civil society speaks out about, because many of these protests and a lot of advocacy is about protecting socioeconomic rights, for example, social justice claims, anti-corruption, etc. And thirdly, it also relates obviously as a norm to human rights because it affects specific human rights, such as the ones that I mentioned earlier, expression, assembly, association. And it affects how civil society can act, because litigation in courts, including the European one, can be a tool for action, also to counter this. So can civil society do something against this trend, and what role could the European Convention play there? Well, of course, there is a possibility to mobilize and lobby for changing these laws, including by asking international and European institutions to speak out, but also to litigate in national courts, constitutional ones, or even the European Court. And this possibility for civil society to do something, and this may be the brighter side, can also happen on the second level of how they are talked about. So they could, and they are starting to talk more about that they actually represent the people and not the governments only, that this has more dimensions than that. And thirdly, civil society has been quite active in creating early warning systems, again, also often involving Council of Europe players, such as the Commissioner for Human Rights, of which we heard some speaker earlier, to help activists, and creating other spaces, sometimes online in other countries. As I know, also in Lithuania, a lot of online spaces for example, opposition in neighboring countries, one of which is obviously not even yet a member of the Council of Europe. So there is a possibility for action, and one of the anchors for that could be the European Court and the European Convention. So there is a relationship of dependence here between civil society that needs Strasbourg, that needs the European Court for the normative protection that I played out, for the procedural possibilities that are there. And if there are more and more obstacles to this, either because of national pressure or because of procedural changes, as the previous speaker has talked about, this makes it more difficult for civil society to operate. But I would like to argue that it also works the other way around. So Strasbourg also needs civil society, because without fuel, the engine cannot run. If civil society in some countries has no possibilities to act because of repression, then simply there are less ways for victims of human rights violations to find the court, to find Strasbourg, but also less possibilities for the European Convention to become a living instrument in those countries. So it works two ways, and this is why I think the shrinking civic space problem is also a problem for the Council of Europe institutions, including the court. So there is a loop, a feedback loop, which goes two ways. I want to thank you for your attention.
Thank you very much for your attention. I hope now you can listen to me.
Yes, we hear you.
Sorry for that, because I was just presenting Antoine Buis, but in reality, I think he was already speaking, but I was not heard by you. So sorry for that, for all these technical problems. Now I think we are moving to our discussion part. So I think we will have very fruitful discussion. Even I think the time for break is already gone, but I still invite you to have like maybe 10 or 15 minutes for discussions, because I think we will receive a lot of questions. And when using this opportunity as a chair of this part, I would like to ask maybe Ineta about this emergency situation in Latvia, because as I have already mentioned during our part 2 of this conference, in Lithuania we have a big legal discussion whether this emergency situation, or let's say quarantine as we are calling it in my country, can be in principle introduced by the ruling which is adopted by the government of the country, but not by the legislator, and whether this would be in line with the, let's say, European Convention on Human Rights and Article 15 of the Convention, which speaks about the possibility to introduce this emergency situation, but informing in an official way the Secretary General of the Council of Europe or Secretary General of the United Nations. How this question has been solved in Latvia? Do you have like different legal positions on this issue or not? Thank you, Ineta.
Thanks. No, we don't have different legal positions on the main questions. We have a special law which has been adopted many years ago, actually, which foresees the procedure to be followed in case of state of emergency. And in that legislation already, you know, whatever, 20 years ago, when the parliament adopted, it was foreseen in case there is a state of emergency, the government under the circumstances, so as not to convene the parliament, it would be too heavy, there is no time. But based on that law, the government had the right within a day to declare the state of emergency. But then what our sort of constitution foresees and our law foresees is that the parliament verifies it. So the government has to go with all of the emergency measures to the parliament, and the parliament goes through, and there was an extraordinary session, of course, of the parliament, and they went through and on periodic basis verifying whether the measures taken, the restrictions imposed and the funds redistributed, whether that is appropriate with the constitution. And of course, in the end, there was always the possibility to come with complaints to the Constitutional Court. And we do have 3 COVID-19 cases right now in the court under preparation. On some of the businesses, a particular type of businesses closed down. These game areas or game business was closed down, and the question is, you know, why this business and not other businesses? So that there very soon, within the months, we are going to, over the winter, the Constitutional Court is going to, without me, I'm still in Latvia, but soon, without me, the Constitutional Court is gonna deliberate those COVID cases. So, and what was very, very important, that meeting of all of the constitutional, the 5 top state officials, because there we basically agreed on how we see the constitution demands, what kind of behavior derives from the constitution, and the feedback from the society was that was really a stabilizing constitutional moment in that state of emergency situation, because if the 3 branches could agree, of course, it's not legally binding, it's a communique, but if the 3 branches of power could agree on what the checks and balances and what the restrictions that they should be applied in accordance with the UN and Council of Europe standard of strict necessity, when it comes to, you know, restricting human rights in the state of emergency, that's also in the communique as a guiding standard. So once that was done, basically in our legal community too, everything was kind of clear when these 5 state officials agreed on some guiding principles. What we did, we underlined the principles that should be at all costs complied with. And there was a problem, and that is still an ongoing problem, whether the parliament can meet on e-platform, whether the constitution allows for e-parliament. Because of course, when our constitution was drafted in 1920 to 22, the e-platform was not foreseen, and that's not expressis verbis provided in the constitution. So there are some lawyers who say that parliament can never be on e-platform, the view that I personally do not share, of course. You have to interpret the constitution in the light of 21st century sort of means, and for as long as, you know, all of the other rules like speaking out, voting, and that is provided properly with technologies in e-Saima, in e-Parliament. It could also be in the computer, you know, in Riga, wherever that, or in Liepāja, you know, wherever the MP is following the self-restraint or even a quarantine. But according to our law, we have a kind of a state of emergency. It's not fully fledged state of emergency, it's true. It's the degree lower in accordance with the law, but nevertheless, so as to be clear with everybody, we also decided to lodge these declarations with the relevant international bodies. The most important rule is what we decided was just to be open about, take the inspiration in these three main things: democracy, rule of law, human rights. That's the basis, and to be open about it, how we are going to function in the state of emergency, internally and externally.
Thank you very much, Dainetta. Maybe other interveners like Mr. Kemp or Antoine Buis wants also to say something on this issue, because in my opinion, restriction of fundamental rights and declarations submitted by the states to, let's say, some European bodies can also be very much important as regards like the civil society and reaction of civil society to like protection of human rights, or for example, as mentioned by Christoph Kemp, maybe this could also have quite negative impact on the protection of minorities' rights during the pandemic. Could you just intervene on these issues concerning the state of emergency declared by the states during this COVID-19 pandemics? Thank you.
If I can very briefly, and I also apologize in advance because I have a follow-up meeting at 1 o'clock, and I cannot cancel that. It's with a governor of one of our OSCE participating states. So I apologize if I tune out in a moment. But I thank you very much, and it was really interesting to listen to the different presentations. On the issue of emergency measures, one of the reasons we wanted to come out quickly with our recommendations is that we wanted to basically say, please, as you develop measures and as you develop emergency measures which sort of are time bound to the COVID-19, please make sure uphold human rights, be inclusive and sensitive to language needs. And the issue of inclusiveness is also very much related to the issue of civil society organizations, representative from communities of national minorities. Because if policies are implemented or developed by authorities on a national or local level, we insist and underline the importance of including representatives from civil society and national minorities as a general principle. But in particularly also in response to COVID-19, to hear what the needs are and to hear what the problems are, to make sure that there is equal rights when it comes to access to healthcare, and to ensure that communication in the language also of minority communities is done properly. So certainly the issue of civil society and the process of inclusion is a very important principle in our overall work as an office, as we advise governments on legal or policy approaches when it comes to national minorities.
And
if I can directly follow up.
And yes, of course, Antoine Buis, I will give you the floor in a second. But until Christoph Kemp is with us today, I would like to thank you very much in the name of organizers of this conference for your time, for your ability to speak today. In reality, it was very interesting to listen to you, and we wish you all the best success. Of course, if you are able to follow our discussions, it would be great. If not, thank you very much for your time to be today with us. And now I give the floor to Antoine Buis to answer from your perspectives my question put to Ineta Zimele. Thank you.
Thank you very much, Chair. Yeah, two things on the state of emergencies. One is that within the Council of Europe states, only a small minority have chosen to officially adopt states of emergencies and inform the Council of Europe about this. So apparently, all the other states, while taking mostly similar measures, think that that is still possible and within the bounds of the normal ECHR system. So we will see maybe in 2-3 years when cases will come about this, whether a difference is indeed made between these two sets of countries. And the second thing is indeed for the role of civil society. For example, in my country, in the Netherlands, there was a kind of quickly made Corona law with all kinds of human rights restrictions presented And then there was an enormous pushback from civil society, including from human rights groups, saying you need to put, as Judge Ineta Zimele basically also said, first democracy, human rights, and the rule of law as the kind of basic starting points, and then start to think of how you then take specific measures from that, but take these as a foundation. And this now starts to seep through. So governments in countries I see go from crisis management towards a more realization, oh yes, we have rule of law as well. And of course, there are also a few governments where they use the pandemic to actually restrict human rights even more, because they now have health protection as an extra justification for measures they already wanted to take.
Thank you very much, Antonio Luis. So maybe Francesco De Santis wants to intervene. And Francesco, could I ask you a little bit to elaborate on the case Burnic versus Ukraine? Because this was very exceptional case, and I think the cases, and maybe our participants do not know exactly about this situation. Could you a little bit say more about why these cases, these 12,000 cases were so exceptional with regards to the execution of judgments and also the individual application rights?
Yes, Chair. As concerns the pandemic measures adopted by Italian government, basically we had the same kind of situation of the one which is been explained. Let's say some administrative decisions and let's say adopted in a framework of a legislative authorization, let's say, and then there's been questioned a lot the compatibility of those restrictions with fundamental rights protected by our constitution. Italy did not present any declaration of derogation according to Article 15, if I'm not wrong, yes, to the Strasbourg bodies. So the convention was applicable during those times. In this regard, as a citizen rather than as a lawyer, because this is not my field of specialization, I would say that I fully understand the point of view of Professor Buis, that rule of law should come first, and then what can we do in the legal framework of a democratic state. Unfortunately, sometimes there are moments where, let's say, the basic needs have the tendency to prevail, and the fear of people. And I would say in March we were really in Italy was, let's say, really shocked by an exceptional situation. So I also put myself in the shoes of government agents to act promptly and adopt measures. And in the end, I think that for democratic states, truly democratic states, there was a kind of exceptional situation, but the rule of law was not under attack back those times. On the other hand, countries which already have some issues with respect of rule of law, they even took this occasion to let's say, to have an excuse to restrict fundamental rights. As concerns your question on Burnic, yes, I said it was really an exceptional situation. The problem arose from the systemic issue in Ukraine from the public bodies to enforce promptly final judgments. The problem was that this was a long-lasting problem since I think beginning of 2000s, and it lasted for a while. So the court adopted a pilot judgment in 2009, Ivanov, and explaining to Ukrainian authorities urging Ukrainian authorities to adopt measures in order to tackle this problem. And unfortunately, for years, what happened when a state do not cooperate with the Strasbourg court, because yes, of course, we have to bear in mind that it is an international court, so it can work if all the member states cooperate in good faith in applying the convention. What happened is that when you have this kind of systemic problem, then application come. So the pilot judgment is the tool to tackle a systemic issue. But what if a state do not act and do not manage to solve the systemic issue at the origin of the problem. So the result was that of having a few Ukrainian colleagues, and I remember them working only on Ivanov type cases, few assistants working mainly with letters related to Ivanov cases, and having a Strasbourg court ruling on already, I think the Strasbourg court did adjudicate something like 14,000 post-Ivanov applications. But then other applications were piling. So at the end, the court, believed that the purposes of the convention were not adequately achieved if the court should rule in other X cases with other, I don't know how many judgments on this kind of post-Ivanov cases. That was an issue of execution of a pilot judgment, and that's why it was for the Committee of Ministers to adopt measures. My criticism in regard to this judgment is that I do understand it was an exceptional case. I remember that as concerns Italy, we had the kind of similar situation in 2011, 2012. We didn't have maybe 30,000 cases, but we had something like 11,000 cases arising from delay of administration in paying Pinto awards. The problem maybe in this case is that the court, instead of saying your well-founded application is struck out and wait for national authorities to adopt measures under the supervision of the Committee of Ministers, maybe in this kind of cases the court could take another step. Use this class action pilot judgment procedure to its extent and ending a finding of evaluation. So I am an international court. I might ask is not that of ruling with 11 or 12,000 judgments on 12,000 applications. I see here there is a problem. I find evaluation arising from Ivanov, and I say state authorities have to pay, in addition to the sum awarded at the national level, 500 euros as a lump sum to each applicant who suffered the same. So like the American class action, with the kind of fluid recovery from victims under supervision of Committee of Ministers. So what I think it was ugly in the Ivanov was not like the decision to solve the issue en bloc, but this strike out because, sorry, this is too much. So this is my point, but I respectfully, as a scholar, I respectfully raise an issue, and I might be wrong. Thank you.
Thank you very much, dear Francesco, for your very interesting point. And as we do not have any questions in the chat, I will close this part 2 of our conference because we are running out of time. And once again, I thank you very much to all 4 speakers, Ineta Zimele, Christoph Kemp, Francesco De Santis, and Antoine Sori-Buis for excellent presentations, for the time you find to be today with us and to celebrate the convention 70 years anniversary. And I wish to all of you the best success in your future activities as regards the effective implementation of human rights. And now I am finishing my role as a moderator of the part 2 of our conference and give back the floor to Katarzyna Miksza for her further points.
Thank you very much, Danuta. So as we are running out of time, so I would suggest us to continue with the third part, where we have also 4 presentations and time for discussion and also for closing remarks. I will be myself the chair of that session. So if we could start with the first presenters, it's Piotr Łubinski and Kaja Kowalczewska from the Pedagogical University of Krakow from Poland. And their topic of presentation is applicability of the European Convention on Human Rights to the Turkish operations in Syria. Okay, good afternoon. I see that Kaja is already here. So the floor is yours.
I hope Piotr is with us. I just called him that.
Yes, I am absolutely with you guys, but I'm obviously giving the floor to Kaja. You don't need to see me. Yes, let's.
Okay, I will continue. So thank you for the invitation, for great discussions, and I believe that our presentation will shift the discussion to different part of role of Strasbourg Court in international law, since we already discussed the link between national regimes and European Convention regimes, but we will go further to the relation between general international law and European Convention regime. So I will share with you our presentation. Hopefully it will work. Yes, share screen. Can you see my presentation? Yes, great. So we will talk about extraterritorial applicability or jurisdiction of member of parties to European Convention, in specific example of Turkish operations in Syria. So something that the topic that is coming and going from court's agenda and is very linked with the military interventions of parties to conventions to other states, to third states. And first of all, we will discuss some factual situation and legal framework that may be applicable. What is also different from previous, and I think that from general papers linked with the European Convention, is that we are not discussing a case that was already adjudicated, but we are rather trying to do it the other way around. So there's still no complaint, but we think that there may be some ground for this kind of complaint, and we are trying to identify some obstacles, difficulties linked with the previous case law of European Court. And by doing so, we feel also to be a bit in a mist, or I don't know how to call it better, but we are very open to all your questions and remarks, because we are aware that maybe we are ignoring something, or we are just not aware of certain concepts. But let me go to the details. So first of all, that kind of general framework, then the question of jurisdiction and attribution of certain acts to a party to the convention, in this case, Turkey. And then I will give the floor to Piotr, who will talk about the specific breaches that we heard about, and question of admissibility of, we call it Kurdish complaints, but of course, the admissibility question is not limited to the Kurds as victims of wrongdoings under Turkish jurisdiction. But since this is kind of a very delicate political question, we decided to focus on Kurdish complaints. So the background is the following. We all know about civil war in Syria that is still ongoing, that is very complex situation with many state actors, even more non-state actors that are acting in place. But we focus on Turkey as a party to European Convention, and also a NATO member state. So a state that is supposed to have some higher standards of human rights protection, of rule of law. And Turkey had led 3 operations and that were called by officials as anti-terrorist operations on the territory of Syria. And they were aimed at the different terrorist organizations like Islamic State, but also other armed groups that are active in the territories of northern Syria. So there were 3 operations with very, I will say, telling names: Euphrates Shield, Olive Branch, and Peace Spring. And now there are ongoing fightings in Idlib region that are not framed in any specific operation, but we know that Turkey is military present and involved in fightings there. So when we try to analyze those actions under general international law, we can look at different frameworks like use of force, so whether it was legitimate or not, what kind of conflict is there? And we know that there are many different conflicts between states, so international armed conflicts, there is occupation, so again, international armed conflict, and non-international armed conflict. And we decided to focus on it because, as it was mentioned also today, this non-international armed conflict situation is much more complex and relevant for human rights protections. So given the deficiencies and some kind of political issues, we can say, we argue that it's highly unlikely that there will be any interstate complaint on the international level, since neither Turkey nor Syria have ratified the Article 36 clause to ICJ. So they didn't accept this jurisdiction. The Security Council is probably not going to address breaches to the International Court of Criminal Court, I'm sorry. So we are left with human rights regimes. And when we compare the efficiency of the international covenants mechanisms that are not judicial by nature, we are left with a European Convention that is actually providing this procedural and substantive help for victims. So having said that, I would like to focus on this question: how can we address the wrongdoings that are happening in Syria and in which Turkey is involved in different dimensions? So we all know that jurisdiction and attribution are kind of controversial concepts in the case law of European Court, and we don't intend to go into this doctrinal discussion whether they are linked concepts, whether they should be analyzed separately and in which order. But what we are trying to take from those questions is the relation between general international law and the European Convention regime. And by saying that, we argue as part of the doctrine, and not only academia, but also judges who are saying that this relation should be, those are not autonomous regimes, totally autonomous. And we should apply certain relevant instruments from general international law. And this is based also on the preamble of the convention that is, I'm so sorry, that is specifying that the European Convention is a regional instrument that is aimed at precising, supporting execution and implementation of rights that were first of all framed in the Universal Declaration of Human Rights. So, so the court needs to take account of those relevant instruments. And in a case of state responsibility, the articles on the responsibility of state for internationally wrongful acts seems as a relevant secondary rules that should be applied. Of course, from the case law of the court, we can track at least 3 different approaches to this relation between general international law concepts. One is to cite different general international law instruments, like also from IHL or the articles, but then not to, usually we have this kind of reference, but nothing, well, there is no continuation in final verdict. And then we have concepts when the court is using those instruments without citing them. And sometimes the court is somehow using them, but not really in a correct way when we look at it from, for example, IHL perspective. But what is important is that combining those concepts is of merit for protection of human rights. And the judicial integration, meaning also taking not only concepts from the treaties, but also from the jurisprudence of other international tribunals like ICJ, ICTY, is of benefit and can reinforce the state responsibility for violations of human rights. So that's why we believe that articles on responsibility of state and the standards developed, for example, by ICTY, could be used by the court. Of course, we are far from foreseeing what is going to happen if the complaint is lodged before a Strasbourg court, but this is more for sake of academic discussion. So first of all, in Syria, there are two types of, two groups of agents that can be linked to Turkey. First of them are state agents, meaning Turkish armed forces, and some subordinate local administration that is being implemented in the territories where Turkey is an occupying power, or where local administrations, small authorities, local authorities are linked with Turkish government. And for those agents, it's easier because we have a rather non-controversial concept that state agents are, state is responsible for state agents, and Article 4 of Articles on State Responsibility is saying that conduct of organs of a state can be attributable to the state, and military forces as well as administrative authorities, they perform inherently governmental functions, and no matter what kind of powers they are. So then we have effective control standard that is well developed in the case law of the court. Nevertheless, this standard is approach of the court towards this standard is rather concealed, and probably you know most of those cases when the court was saying about the extraterritorial principle and was referring to different standards under one name of effective control standard. So this is a very confusing standard for us. Because we come from such a high level control standard as being physically present, financing, where we have to see how many soldiers are there, how long the control lasts, and what is the degree of that control. And then in PAD, for example, case, we have the statement that the jurisdiction can be established by the fact that the victims were in the range of the gun deployed from helicopter. So some two very extreme different approaches. But as we said, military, Turkish military is present on the spot in Syria, and this jurisdiction is rather uncontroversial. What is problematic is the use of proxies. This is not a new phenomenon. This is something that was already used in many wars. We can hear, for example, for example, private military companies used by United States in Afghanistan or Iraq, or more recently, Little Green Men deployed in Ukraine. And here in a Syrian conflict, Turkey is somehow directing and using rebel forces that are against local governments for its own sake. And for the purpose of this attribution, we would go to the Article 8 that is saying that the conduct of private entities, private individuals or groups can be linked with the state if we can prove that those entities were working under instruction, direction, or control of the state. And in this case, we don't need an official link. It's also a factual link that is enough. And this is more helpful because there was no official incorporation of those rebels into the armed forces of Turkey. But what is common for all those kind of situations is that the fact that we are outsourcing, the state is outsourcing a certain public powers, functions to privates, and by doing so is trying to tackle some delicate issues or to perform some actions that would be otherwise seen as illegal. So Article 8, but then also the overall control standard used by ICTY in a well-known Tadic case of appeal chamber. In that case, the ICTY said that when we don't have enough of control, the level of control is not high enough as it was before stated in Nicaragua judgment, where there was a very high standard of control, and not only financing, training, supplementing rebel groups, but also being physically present. Then we believe that this overall control standard could be used for rebel forces operating in Syria under instruction of Turkey, given the fact that certain sources are citing a very tight connection of those rebels to military power of Turkey. The good example is the Battle of Afrin, where the rebel forces were entering as the first line of soldiers, doing some cleaning the territory, let's say, making it safe, and then the Turkish armed forces were entering in second place, just to control the situation that was already somehow solved by the rebel forces. But we are aware that the overall control standard was until now not used by the court, or maybe we don't know about this case. So please point it to us if we are mistaken. And it can be also very hard from the evidentiary side for victims to present this kind of proofs that can confirm this kind of control over rebel forces under ongoing conflict. So the last concept that we would propose would be the positive obligation bridge. So once we decide that Turkey has its jurisdiction in northern Syria, in the territories under its occupation, it stems from there that it should take all necessary measures that are available under the certain circumstances of occupation. So not a normal state, more like emergency state, different from COVID though, to safeguard rights of people who are under jurisdiction of this party to the convention. But of course, this concept is not, in this case, is not playing the same role, because probably Turkey wouldn't be held reliable for the responsible for the actions of rebel groups that are seemingly controlled by it. This is from me all. Piotr, this is for you. Thank you.
Do you hear me? That's the first question. Oh, you don't hear me.
We hear you, we hear you.
Oh yeah, excellent. Because I'm trying to like set up few things like separate camera and separate microphone, and obviously I'm not great at it.
Visible and we hear you. Now
Excellent.
We don't see your presentation anymore.
Kaya, I thought that you can leave the presentation because it's the same presentation. But if not, then I will try to. Oh, excellent. First of all, it's a great pleasure to be, at least virtually, at the in Vilnius at this lovely university. It's great pleasure to see you, Justinius, and other friends. The person whose name is Nicolas Romero his history shows how difficult is history between Poland and Lithuania. So it's excellent to be at this place. In regard to our presentation, I would like to, because as Kaya pointed out, we strongly believe there is a ground for cases before European Court of Human Rights. However, there has to be a breach of the law, which gives a ground for a further procedure. And obviously, the two most easy to prove before the court is Article 2 and Article 3, right to life and freedom from torture. Since Kaya divided into two parts, which is basically actions of the armed forces, Turkish armed forces, and proxies actions or non-state groups, rebel groups, I will also divide those breaches in one which could be attributed to the state and one which could be attributed to the non-state groups. There are several reports which confirms that during the several military operations as Kaya presented, there were a massive violation of right to life by Turkish armed forces. Already mentioned Battle of Afrin is an example of indiscriminate aerial attacks, bombing civilians in Syria, in northern Syria. This is obviously a violation of Article 2, and there is a long line of case law which provides that obviously right to life protected under the conventions, also protected during the armed conflict. This is a case of Ergi against Turkey, and obviously the whole group of cases related to Chechnya, where a European Court of Human Rights pointed out that obviously right to life is protected also during armed conflict. Even more gruesome informations are related to the actions of Syrian human rights observation body indicates extremely violent and brutal pictures and cases of tortures committed by the non-state groups. I'm not obviously going to present all pictures or detailed descriptions of these tortures, but let me point out that it was several confirmed cases also by international community. One of the most brutal examples is killing, torturing, and mutilating Kurdish female politician Hevrin Khalaf. She was ambushed on the way in northern Syria, and then she was tortured, killed, and mutilated. Article 3 is obviously protected, or freedom from torture, obtained protection during the armed conflict. It's again Turkish cases like Benzer versus Turkey, or Chechen cases Eshmo Kabatov and others versus Russia, where it was found by the court that freedom from torture is obviously non-derogable right also during conflict. There are several reports. Obviously, we are going to happily provide this information later during the discussion or in a paper article, which we are going to submit after this conference. But not only Amnesty International, there are certain UN bodies which indicates that massive violation of both Article 2 and Article 3 is taking place, and crimes are committed both by armed forces, regular armed forces, Syrian armed forces, and let's say non-state agents, proxies, such as, I don't know, Sultan Murad, for example, which is a famous armed group because it's operating not only in Syria but also Turkish apparatus is recruiting a member of this group to fight in Libya as mercenaries, and they offer them citizenship because of that. Other violation of European conventions also taking place. Certain area around Afrin and other northern Syria area were looted on a mass scale. Turkish officials officially accepted this practice, saying that it constitutes a legitimate seizure because it prevents the generation of income for persons belonging to PKK, which is People's Kurdish Party. And obviously it's almost unbelievable that a minister in one country accept illegal looting in other country, saying that it's well-founded or reasonable measure. But obviously, it's not only important to prove that we have an effective control or overall control of the crimes that are committed, but also to proceed these cases before a European Court of Human Rights. Certain formal requirements has to be fulfilled, and obviously, European Convention of Human Rights provides those admissibility requirements in Article 35, and obviously you probably know it better than I. But we established that there is ratione persona jurisdiction. There is this effective and overall control, which gives a ground for complaints. Article 34 provides that complaint may be brought by direct or indirect victims, which in our opinion are all members of the populations affected by these operations, which will be Kurds and other ethnicities or other groups which are living in a territory of northern Syria. Obviously, not only ratione persona, but ratione materia. This is again seems to be proved. What is obviously debatable, because temporal jurisdiction or like a 6-month limit is not debatable. It's exhaustion of domestic remedies. According to Article 35, the court may only deal with the matter after all domestic remedies have been exhausted according to generally recognized rules of international law. And this, my short part here, actually deals with a lack of capacity of a Turkish legal or jurisdiction system to deal with this case. Because Turkey is a country which was highly affected with the growth of authoritarianism and especially in a post-coup area, and Erdogan post-coup purges, which result with rather unprecedented policy and unprecedented purge against its own judiciary, own military forces, own administration apparatus, etc., etc. Just enough to mention that 4,000 judges and prosecutors were detained, fired from its offices during this post-coup situation. We strongly believe that currently Turkey is simply incapable to proceed those claims, and due to the influence of executive branch on judiciary, and the fact that even dealing with this post-coup cases, Turkey is unable to provide a fair trial standard. So we assume that taking into consideration the lack of ability of a judiciary system in Turkey to proceed with cases, we simply believe that applicants can be exempted from this requirement and bring their claims directly to the European Court of Human Rights. Why is so? Just because probably we already are talking way too long. So just 3 minutes. First of all, the major institution which deals in Turkey with human rights cases is a constitutional court. But the constitutional court was flooded with cases related with coup. Secondly, judges in the constitutional courts were dismissed and detained as a part of those purge. And the third one is that the Constitutional Court rejected several cases related with a coup. Why it's relevant to Operation Turkey operation in northern Syria? There is one common denominator, which is terrorism, because Erdogan is claiming that coup was a terrorist operation, and also he's claiming that their operation in Syria are also anti-terroristic in nature. So we are afraid that actually bringing these cases to Turkey against Syria will be also rejected by the local courts or Turkish Constitutional Court. To deal with purge, Turkey established inquiry commission, but this is basically not a court. It's an institution which is supposed to support this post-coup complaints in the Turkey, but it's so much dependent on the executive branch. The persons which are sitting in this commission are not fulfilling requirements of being independent judges, because they are dependent on executive branch, and obviously there is some time limit when are sitting in this body. So it is not a place where, for example, victims of a military operation in Syria could bring their case. These findings are supported by the report of Duna Mijatovic and her report following her visit to Turkey in 2019. She pointed out that judiciary is in danger, that there are some shady body which are firing judges, such as High Council of Judges and Prosecutors, and simply it's hard to right now to say that judiciary system in Turkey is independent. As such, we strongly believe that applicants from Syria should bring their complaints directly to the European Court of Human Rights, because this is the only remedy they can have under current situation. Why this is so important, finding this remedy? Because we are operating in sort kind of a gray area of applicability of European Court of Human Rights, and as Kaya pointed out, it is very useful for states to avoid responsibility by using proxies, and this use of proxies on this scale, as is doing Turkey in Syria, may be a pattern or matrix for a future use of potential violation of human rights. Obviously, our findings may be applicable in Russia, in Ukraine in case of Russian engagement, and especially the operation in Donbass and Lugansk, where so-called democratic republics are operating often under control, effective and overall, from Russia. So we can we believe that these findings could be applicable in other places where a European Convention of Human Rights state party is violating human rights using proxies. And maybe I will finish here. Yes, let's discuss, or we will wait for questions later.
Thank you very much for Piotr and Kaya for the great presentation. Discussion is at the end, so please prepare the questions. And now I have a very big challenge because I have the presenter from Hungary, and I'm not sure if I can pronounce the name correctly. The name is Gostoni Gergely. Excuse me for sure it was not correct pronunciation. Do we have the speaker among us? Okay, I don't see any reply. Okay, so I will try to contact the speaker, but meanwhile, we can go to our another presentation. And our next speaker is Laima Vaige, who has PhD from Miguel Romerus University, but at this moment she is in Uppsala University in Sweden, and Laima will speak, as far as I know, about women's rights during crisis. Laima, you're welcome.
Thank you very much, Katarzyna. And I am very happy to be here, and thank you for the invitation to the conference. And I'm very impressed how smoothly it goes. And the reason why I'm going to talk about women's rights during crisis is because well, first of all, I wrote my dissertation on violence against women, so I'm rather engaged in women's rights. But also because during the COVID pandemic, I saw a couple of headlines in the media where it said that women are kind of lucky during the pandemic. And in particular, in the Lithuanian national media website, there was a title said, who won in the lottery of genes? And it was apparently a woman that won in the lottery of genes because they were less likely to die if they got sick with COVID-19. I was a bit perplexed because, in fact, the United Nations are of the opinion that women in the long term are very likely to suffer quite harsh consequences of this crisis, and not only because of the COVID-19, but also because of the intersections of the crisis that we are finding ourselves in. And today I'm going to talk about two of these crises. One, the crisis with the rule of law and democracy, lack of democracy, as well as COVID-19. And I would like to start actually with the crisis of democracy, because even in our neighboring and very dear to us country, historical Poland, quite recently in May, I was quite astonished to see that Freedom House has evaluated this organization, this state, as no longer full democracy. It was going down the index of democracy since 2016. And now in May, Poland is no longer in the section for consolidated democracy. Hungary was no longer evaluated as full democracies for a couple of years now. And what can we say about Belarus and Russia, also the closest neighbors? Belarus, Minsk is only less than 200 kilometers from Vilnius. There's crisis to the extent that there's even a fear of the very ground of European Union. United Kingdom not only did it leave the European Union, but also plans to recall its Act on Human Rights. In the United States, we have burning San Francisco, but also burning hope for human rights. And Donald Trump, who is quoted in the media all over the place, I think is dangerous not only because what he does, but also because he has the very rare opportunity to appoint a couple of Supreme Court judges, which doesn't happen very often. And now Ruth Bader Ginsburg is also sick, which means appointing Supreme Court judges determines the future of law, case law in the United States for decades, perhaps half a century. So women's rights are exactly the target of this crisis with democracy, because they do not fall into the plan of the new governments who aim at establishing or coming back to the traditional values. For instance, elimination of the right to abortion becomes a symbolic sacrifice to coming back to the traditional values. And in the United States, for instance, it is only established in case law of the Supreme Court, which can decide differently in the future. Planned Parenthood organizations are being closed because of abortions being performed there. But at the same time, it's also the opportunity for getting treatment for breast cancer, cervical cancer, reproductive rights. During democracy crisis, women's participation in the politics also decreases. That we can see everywhere, including Lithuania. Just a couple of years ago, it was the only case in Europe that we had 100% male government. And then there was one minister invited to join the government, but unfortunately, with regards to the woman that the ruling party is letting to speak in the name are not actually representing women's rights. So if we look at politicians such as Agnė Širinskienė or Rita Tamašūnienė, they are very strong and fierce, I would say, builders of the traditional system. And at the same time, they imitate representation of women in Lithuanian politics. So we should not be fooled by the appearance of one or two women among many men when they are the builders of a traditional system. Even in The Handmaid's Tale, we had the so-called aunts who were responsible for training the handmaids and just monitoring values. There is also very strong resistance against the Istanbul Convention, which is all over there, everywhere in Eastern Europe. And here I would like to quote one convention, Article 5, just as it stands. So state parties shall take all appropriate measures to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of inferiority or superiority of either of the sexes, or on stereotyped roles for men and women. So this article called Sex Role Stereotyping and Prejudice, many Lithuanians would say, well, thank God we did not ratify this convention, but in reality we did. This is the Convention on Elimination of All Forms of Discrimination Against Women that is valid to Lithuania, that is enforced since 1994 in Lithuania. And I'm quoting it not because I want to remind you that ratified international treaty actually has superiority to law, which is true, but also because the very content of this convention that was passed in 1979. So the discussions about women's rights, they were ongoing during the last century, 50s, 60s, and finally in 1979, states of the United Nations were willing to take this obligation to shall take. I mean, you can see the very weight of this international obligation to eliminate sexual stereotyping and prejudice. I wonder if in 2020 we would ratify this convention, and do we still have this commitment to eliminate this idea of inferiority or superiority of either of the sexes and stereotypes? So it's a rhetorical question, because in Lithuania it's the orientation is again towards the traditional values in the legislation, even though the Constitutional Court has been rather progressive. But the legislature adopts laws that are the basis for creating power structures for traditionalists, family policy that protects traditional values. And the gender equality is actually presented as something that comes from Soviet Union, which is paradox, because in the Soviet Union we had the cult of the father of the nations. All of the leaders of the Soviet Union were men. So to return to the somehow lost masculinity and the value of men as the heads of families and leaders are actually very strange and very limiting, both to men and women. Gender role of men here is described as political and economic power, whereas women have the function to help men in any ways, thus supplementing them. And this represents a hierarchy of genders, but also hierarchy where families are under the hierarchy of the state, and then the state ruler to God. This is exactly the traditional gender ideology, actually, even though gender ideology is called the vision of gender equality in Eastern Europe. And crises, they don't come alone. So now with the democracy problem, we also have the COVID-19 pandemic. And when most of the resources go to fighting the pandemic, there's increased danger to health of women because of risky pregnancies, unsafe abortions, violence in the family, violence outside of family, sexual violence, ignored sicknesses. Many of the rights of women in Lithuania, for instance, as well as all over the world, are established in rather unstable measures. For instance, we have a substatutory act that establishes right to abortion in Lithuania. That can be recalled at any time or suspended or changed. And if it's considered not to be necessary for human life and health, then that can wait. Now, when the schools are being closed, of course, that's very unfortunate for children, but also where do all these children end up? The responsibility for children then is on the parents, and mostly on women. They are faced with the task to make sure that the children are physically safe, they are educated, the mental health at the moments when mental health of everybody is shattering. Furthermore, United Nations on the world basis in developing countries, they did gigantic work trying to show that the welfare of the society actually depends on girls going to school rather than staying at home and being married and then giving birth from their early years. And now this work is going to waste. Millions of women now under the danger to be forcefully married, facing early pregnancies, unsafe pregnancies, and so on. There's less opportunities. The economic poverty that is expected, that is prognosed because of the pandemics, again, long-term consequences are harsh on women. According to the data by United Nations, 47 million of women are facing the risk of extreme poverty because of COVID-19. Previously, there was a prognosis that the gap of poverty is going to be less than 3% between men and women. Now it's more than 9%, so it gets 3 times as bigger, and in 2021 it's more than 11% gap in extreme poverty. Women are also quite often workers in the households, both for free and also as freelance labor. And in accordance with International Labour Organization, 72% of these types of work disappeared during the COVID-19 pandemic. With regards to violence, I think I could speak a lot, but I think everybody knows by now that when you are locked, when you are in the lockdown, violence increases and accessibility to help decreases or is almost impossible to get. And even though in Lithuania from 2011, there is a network of help provided with regards to domestic violence, there's no help, for instance, with regards to rapes on dates, parties, streets, public places. This crime is not considered to be of societal significance. So there's no rape crisis centers, there's no help by phone or any kind of attempt to lower this degree of violence. And then you can say, well, but why are they going on dates during the pandemic? But life is going on regardless of the conditions of war or sickness or whatever. And women are not protected at home either. It's not only about meeting new people, but also about being stuck at home. So I think all of this leads us to the question of crisis of values, really. What is the most important value at the moment? And I would like to quote, or I would like to mention one case by European Court of Human Rights. It's actually a strange case because it is about freedom of religion, and the decision is Sass versus France about the veiling of women's faces. So the European Court of Human Rights agreed that France, the prohibition of France to have full veil covers of women is justified because of the requirement of living together in the civilized society. And that sounds very, very paradox at the moment, because only a couple of years ago, women's face could not be covered because of the requirement of living together in a civilized society. And then just a couple of years later, now we have an opposite requirement. Living together in a civilized society requires to cover your face. So I think that it shows that the main principle of living together while being very different in a society and also in the international community should be based on something else than, you know, how it looks, clothing, style of life, things like that. That should not matter. It should not matter that it's disgusting to somebody how the neighbor is dressing or with whom she's going out or what religion she's practicing. It's more about long-term values, long-term principles, such as democracy, rule of law, human rights and freedoms, all sorts of people, their differences, families, environmental protection, and most importantly, equal value of all humans without saying to anybody how we should be dressed or how we should live. Thank you.
Thank you, Laima, for a nice presentation. We already know that women are facing, as the convention itself, are facing really a lot of challenges. We will be able to discuss for sure some questions a bit later, but now I know that our participant from Hungary is already here, has joined us. So Gergely, if I could ask you to switch on your microphone and camera. If we can proceed with your presentation, and if you can start with correct pronunciation of your name and surname, because I don't want really to misspell it, mispronounce.
Hello there, and hello everybody. Thank you very much for the invitation. The correct spelling is Gergely, but nobody knows that because the Hungarian language is so difficult that we have the L with the 2 letters. We use it as a 1 letter, so don't worry about that. This is Gregory in English. I always tell my friends to call me Greg, so that's just perfect for them. Thank you very much for the invitation, and I don't want to ruin all the time, so I start to talking, and I bring a presentation. So I will share my my screen so everybody could see that. One sec. At least I'm trying.
Well, it's just share the screen. I don't know. It yes. Worked today, so if you could try. You see that greenish.
Yeah, I know. I have some. Hold on, 1 sec.
We have some unexpected break. Let's hope our presenter is coming back in a moment. He asked us to wait just few seconds, probably to enter the system one more time. I suggest meanwhile everybody, oh, he is already coming back. So I would suggest everybody to think about the questions that we will have after the presentation. Okay. Gergely, you are back, but you have to switch on your microphone. Microphone switch off, please. Switch on. Gergely, you are muted.
Muted. Okay, so back now. Okay, terribly sorry. I had some system issues, so I shared my screen. I hope everybody could see it and could hear me. So thank you very much again, and I'm starting my presentation. So what I'm going to talk to you for 15 minutes is the brand new way of communication. So I'm dealing with freedom of expression and freedom of speech and all these kind of things, and related to not only the European Court of Human Rights, but the other international courts also. So, but right now we are talking as a presentation, or we are talking about the European Court of Human Rights. And one very special, one very small aspect of the freedom of speech as the access to the internet, and how it, in the case law of the European Court of Human Rights, we could find this interesting question. What we saw here that in there are some landmark cases according to freedom of expression and according to the use of internet. And in 2015, there was the Cengiz and others v. Turkey, where the European Court of Human Rights stated that the internet became one of the principal means by which individuals exercise their right to freedom to receive and impart information and ideas. It's very good to have that information in 2015, but at least we could say that the European Court of Human Rights realized that the media field completely changed in the last 15 years and in the last 20 years. So they realized that the access to the internet and all these related questions are as much important in relating to the freedom of speech as, for instance, print press or other means of communication, or the electronic media as we use in the last 20 years. there was a quotation I brought to you, which said, it was the Commissioner for Human Rights who said that internet blocking is a widespread phenomenon in Council of Europe member states. And that I would like to show you that this question, the access to the internet, this freedom of expression thing, here in Europe, we always think, or we try to think, that this is from the far east. So this is definitely in China, in North Korea, or in Cuba, or whatever they could. But it shows that this question and this technical and legal question is reaching our countries, and I will show you the signs that we should be aware of. So first thing, I don't know if you know this beautiful picture, who's the president of Russia, of course, the President Putin. And there was some years ago, it was in 2017, it was in Russia, it was a well spread image. And two things happened. The first one is anybody who spread this image could end up at court, in front of the court. And what's much more important for me is that the reason or the justifying why they were brought in front of the court were two-sided. The first one, well, I don't like this picture, but there are some who likes that. But harming rights relating to personality, we as lawyers, I think we could understand that. But how in the earth is this supporting terrorism? I have very serious concerns about that. And the question is, and that's why I brought to you, that the states are getting more and more new ideas, how they could end reaching people. I mean, how could they end that the information could reach the end users? How could they stop spreading the information on the internet? And what we will see, and what's the most alarming, is that right now they have this big red button, and they just switch it or press it or whatever, and they could shut down the whole internet for a whole country. It was this is not in Europe, but it was in Africa, that a whole country was shut down. I mean, 98% of the country was shut down for a week from the internet this summer. And it was because of the COVID virus, but we saw that it was much more related to the elections that were held there. But I will get to that information also. Let's get back some moments or some years. And in 2011, the UN Special Reporter for promotion and protection to right of freedom of opinion and expression, they held or they gave some documents, and they said, it was 10 years ago, and they said that there are arbitrary blocking in several countries, and the blocking means that the countries stop the information to reach the end users. And I don't want to go into very technical details because usually lawyers don't like that, but there are several ways to do that. So there are ways that for stopping website, there are ways to stop IPs, addresses, domain names, several other technical issues. And we have to think, and we see that in the practice, that the governments could find new and new ways to do that. And I bring you the very recent numbers. In 2019, 213 documented internet shutdown happened in the world, and there were 33 countries in the world to use this practice. And if we see the image on those countries on the map, we could see that there are, if you see, there are European countries also. So there are democratic countries and Western democratic countries, as we usually call them. And one of the main, one of the biggest surprise for everybody was the UK, because, well, for instance, I have to say that there are some who think that Russia could do anything, and Russia, it's not a surprise for them to do that, but United Kingdom was a new perpetrator in that sense. So let's get to the European Court of Human Rights practice and how the European Court is dealing with this question. This is a pretty new question, so we don't have too much case law, but I brought you only the landmark cases and the most important, or what we see, the most important cases in relating to stop the internet, how they block access to the internet. So the first one was not the first case, but the first case I brought you here is Akdeniz v. Turkey from 2014, and it was not a decision because, or it was a decision, but it was not a final decision. So it was a question of admissibility. They asked that there was two websites in Turkey that was completely unable or blocked for the users, for the end users. And those two websites were MySpace and Last.fm. I don't know if any of you remember those two sites. They were very, very famous at, I don't know, 15 years ago or something. MySpace.com, maybe you know that. Last.fm, I didn't know if it still exists, but just checked it 10 minutes ago and still exists, but nobody's hearing that. So basically, the court declared the application inadmissible because they say that just because, and Last.fm was a musical site to share music and tag music at that time. And the court said that just because there is a website that is blocked, the users could reach the information. In that case, they could reach the music, they could get the music from different sites. So just because there is a blocking, it doesn't mean necessary that the courts made the wrong decision. So there could be ways where the court could block different sites. I think that was I think that's the first thing we have to admit. And the other one is Ahmet Yildirim v. Turkey, and we see that the cases I brought to you are basically Turkey and Russia, and I admire Turkey, to be very honest, because Turkey, I will tell you why. So Turkey blocked the whole Google, and just I don't know if you use today the internet, but I'm pretty sure that if you are looking for something, you go to Google, and there was a single website, nobody's reading that. And there was a single website, and it says that, Kemal Atatürk, the founder of the Turkish Republic, it said not very nice things to him. And the Turkish state decided not to block that single website, but they decided to block the whole Google, which is, well, it seems a bit too much for me. So it's called wholesale blocking. And of course, Ahmet Yildirim went to the ECTHR, and the court found that it violated Article 10 of the European Convention. And there were three reasons for that. The first one is that the court said that a ban could happen. So it's not a problem to have a ban, to have a blocking of a content. There could be several infringements that could be stopped only with blocking. So that's not the problem of the court. The problem of the court was that in the Turkish legislation, there was no justification for the ban. It was just a wholesale ban. So the Turkish government could ban basically anything for any reason. And the court says that this is way too much. This is too broad. And the other one is that the Turkish government and the Turkish court didn't try to go for a smaller method or for a smaller reaction. So they just did a wholesale blocking, and they didn't just block the single website. So the court said that this was the Article 10. I don't know if you remember the reaction of Turkey. Turkey said that, okay, it was a mistake. We put Google back and we stopped blocking. Yes, some years later, they blocked the whole YouTube. So to be very honest, I don't really understand that. But that was basically the same cases. So Turkey blocked the whole Google, so that was a wholesale blocking of YouTube. And then the court decided that it violated Article 10 of the convention. No problem at all. And there was one more thing that the court said in this case, and it said that we should consider the timing, the length of the blocking, because for a short time it is possible even the wholesale blocking, but for a longer period of time, it seems that stopping people from the access to the internet and stopping people for impart information and receive and impart information and stopping people for getting the knowledge and to take part in the democratic society, it's basically against the article and against everything that we could say. Another case or other cases, these are very, very recent cases. These are from this June this year. Those are non-final judgments. And these are Russian cases, very, very similar Russian cases when Russia blocked several websites. And we could see here, and I really love when I'm reading decisions of the European Court of Human Rights, and I read things like collateral blocking and wholesale blocking and things like that. That means that's a very, very different type of technical blocking. But they say in that case that if there is an excessive wholesale blocking, it's definitely against the international standards, and we need proper safeguards against the government's actions in that case. And you could think that after those things, and after having 2 slaps from the European Court of Human Rights, Turkey decided to stop the practice of wholesale blocking. No, definitely not, because some years later, Turkey blocked the whole Wikipedia. And they blocked the Wikipedia because there was one single article on Wikipedia saying that Turkey is sponsoring the ISIS. And there was some oil trading or whatever, it was not so important. But then the reaction was again to block, to do wholesale blocking. And Wikipedia filed an application last year to the European Court of Human Rights. And the strange thing is that Turkey didn't wait for the final judgment. Strange or not strange, but there was, just after the application, there was a Turkish Constitutional Court decision saying or stating that this wholesale blocking of Wikipedia was against the Turkish constitution. So they, I don't know how to say otherwise, they flee away. So they didn't wait for another slap or for the same decision. Those are very similar circumstances. I'm pretty sure that the decision would be the same. But those cases are very, very, very similar in relation to the access of the internet. And there were one slide I skipped, and it has a reason for it, because accessing to the internet has a very subsection for the prisoners' access to the internet. There are 2 very famous cases, one for Estonia and one for Lithuania, and just in a nutshell, the countries are allowed to stop the access of prisoners to the internet, but if they give access or if they grant access to the prisoners, then they should justify why they block certain sites from this information. And I was talking about Europe, and I was talking those questions, those infringement of freedom of expression, freedom of speech, and all the related questions are coming to us. So there was a Mapping Media Freedom website, and this is the almost closing my presentation. And in the 4 months of the COVID virus in this year, there were 19 issues against censorship, and there were 19 issues dealing with the access of the internet in Europe we could all find our countries there. I see my beautiful country with 4. I'm not really proud, to be very honest. I have to say that. And it was the 20th of July, so the end of July, I can't remember the name, when the UN Special Rapporteur gave another document or issued another document and raised serious concern. And he called the governments to end the practice of internet shutdowns and other limitations on access to the internet, because as we all know, the worst thing about censorship is. Thank you for your attention.
Thank you, Gergely, if I'm correct, for your nice, very informative presentation. And we are moving to our last but not the least speaker. The last speaker is Associate Professor Laurynas Biekša, who is an associate professor in our Institute of International and European Union Law. And his presentation calls Protection under Article 3 and Protection under Asylum Law. You're welcome.
Hello, Katarzyna. Hello, everyone. Thank you for possibility to participate in this conference. And I will use this chance, as some previous speakers, maybe not to compliment European Court of Human Rights, but to pay attention to some problematic issues in the practice of European Court of Human Rights, which I hope could be solved. As we all know, convention is a living document, practice is evolving. So I would hope that ideas which I'm going to present in my presentation today could be useful for also as ideas for developing the practice of European Court of Human Rights. So yes, I'm sharing my screen in order to show.
There is a green. Okay.
Is it okay?
Yes.
Is my screen visible?
Yes, the screen is visible.
Okay, thank you. So, topic of my presentation is protection under Article 3 of European Convention and protection under asylum law. And as you could already understand from my introduction, actually, I am going to pay attention that protection under Article 3 of European Convention is lower than the protection under asylum law. Yes, I understand that one could immediately theoretically reply that both protections, they do not have to be at the same level, but actually today we have situation that both European Court of Human Rights and European Union Court of Justice, both courts are interpreting the same Article 3. European Court interprets Article 3 in situations when people have problems in their home countries, and if those problems amount to violation of Article 3, then European Court guarantees non-refoulement, that those people are not sent back to their countries. And the same actually provision is applied in asylum law in European Union, as qualification directive regulates that if we have violation of Article 3 in home country, then person must be granted at least subsidiary protection. If it is for some serious conventional reasons, maybe even refugee status. But okay, in order to make it simple, let's say that subsidiary protection is granted exactly on the same ground. If it is violation of Article 3, EU qualification directive requires to grant subsidiary protection. It means both courts are interpreting Article 3. And yes, again, theoretically, one could say those might be different interpretations. None of the courts are ready to subordinate to each other's practice. But here, I would be simplistic as human rights lawyer myself. I think that it is still would be the best situation that both courts would achieve the same standard, and it is recommended that it would be higher human rights standard. That's why during my presentation, I would explain what is lacking, what is missing in the practice of European Court of Human Rights today in order to achieve higher standard, which is today already regulated by European Union asylum law. So pictures on this first slide are from Belarus. We have crowd of protesters on one picture and some of protesters being beaten by OMON. And I'm afraid that according to the practice as it is in European Court of Human Rights today, those protesters, if we go outside Belarus and ask not to deport them back to Belarus because they are afraid to be beaten, I think probably they would not succeed to get protection under Article 3. I will explain later why. But under asylum law, my opinion, they must get that protection. So that's why it is also important maybe to develop that practice under Article 3 of European Convention. Okay, then now I'm going to substantiate my claims. Okay, so first gap of protection, I will call that gap of protection, but I understand theoretically this is not gap, but I'm talking about ideal system which I would like to have, that same standard and higher human rights standard. And in that sense, this is gap of protection. So first of all, on right column, you can see provision of EU Qualification Directive, Article 7, which regulates standard that we could send people back if in their home country, country of origin, they can get protection from state or parties or organizations controlling the state or substantial part of the territory of that state and operating an effective legal system for detection, prosecution, and punishment of acts constituting persecution, serious harm, or in other words, we can say constituting violation of Article 3. So people must be protected against violation by their right under Article 3 not to be tortured, not to face inhuman treatment by state or organizations operating effective legal system. And now let's notice the practice of European Court of Human Rights in this field. In the practice of European Court of Human Rights, we find such a low standard, which is surprising. In the case when Yemeni women were not protected under Article 3, they were fleeing from Yemen because they were trying to escape domestic violence and also forced marriage by the husband and father of that family. The court finally decided to send them back to Yemen. It is okay, it's not violation of Article 3, because that woman, mother of that family, had a brother somewhere in Yemen, like we told, moving around Yemen. Also, they had 2 adult sons, and also we have some other brother living in London who might provide additional support. This all is written in paragraph 83 of the decision. So compare the standard. On one hand, the standard of state or organizations running effective legal system. And here, yes, you can find some, private physical person who maybe that person would protect you. Maybe your brother, maybe your uncle would protect you, who knows? And in the opinion of European Court of Human Rights, it is enough. It is enough to send people back with this type of protection. Okay. Assume that those people, brother moving around Yemen, another brother in London, and 2 adult sons, maybe they are capable to provide protection. Let's assume they are capable to provide protection. But then, in my opinion, common sense logical question is, would they be willing to provide protection? What they would ask in return for providing protection to that woman. So this is not real protection. So, and this is the standard which we could find today in European Court of Human Rights cases. Second case, also women fleeing from forced marriage. And again, European Court of Human Rights decided that it is okay to send her back to Mogadishu, Somali collapsed state with no state protection, because she still has some contacts in Mogadishu, including brother and uncles, and therefore she must be considered to have access to both family support and male protection network. So this is the standard of support, some kind of male protection network. Come on. Again, we have collapsed state, women in danger of forced marriage, domestic violence, and European Court of Human Rights thinks that it is enough to have some male protection network. Again, who would guarantee that those male protection network is ready to protect, is willing to protect? Again, what woman would have to give in return for that protection? So, okay, I call that gap. Then second gap. Again, first standard of asylum law in the European Union. We have at least two European Union Court of Justice decisions where in asylum cases are clearly stated that when we are dealing with problems in the country of origin, assessing an application for asylum, authorities cannot reasonably expect that applicants to hide their religion, to hide their sexual orientation, or to hide their sexual practice, or to hide their political opinions. So in asylum law, it is clear that if we wish to have effective protection for that person must get that protection, not hiding his political beliefs, not hiding his sexual orientation, not hiding his religion. Only then we could say that we have protection. If person is coming back and pretending that, okay, I'm not of that religion and therefore he's not facing problems, this is not protection. This is just person not living normal life, because that person is not practicing his or her religion or not living according to his or her sexual orientation. And now let's again notice the standard which I found in European Court of Human Rights case. In this case, European Court of Human Rights told that it would be okay for person to go back to Libya and pretend for maybe for approximately 4 months that he is not homosexual. That person actually in Sweden, he is homosexual, and in Sweden he has concluded marriage with another homosexual man. But if in Libya people would know about his homosexuality, a big problem would be for him. So proposal of European Court of Human Rights to go back to Sweden, to Libya, and just to hide this. And also what is interesting, why European Court of Human Rights proposed to hide that for 4 months? Because in that case, Swedish migration authorities told that if that person would go back to Libya, then submit application through migration procedures regarding family reunification with his husband in Sweden, then it could take, if it would go smoothly, it could take like 4 months. So again, as myself being practicing law in the field of migration, I'm sorry to disappoint European Court of Human Rights. It is optimistic thinking. If you go into migration procedures, your migration procedures first of all, they could fail at all. If you fail to provide any document or any document with right apostille, you could fail to receive your migration status at all. So keeping this in mind, we are saying, okay, go back. Maybe you will be lucky. Maybe you will solve your problem in 4 months. So it is not a big problem that in Libya, you would hide your homosexuality for 4 months. That's okay. In my opinion, this is again below the EU asylum standard and also below the common sense human rights standard. Okay, then gap number. I could also propose more gaps, but as my presentation is supposed to be short, I just picked those gaps which are, in my opinion, like maybe the worst, which maybe should, in my opinion, should be addressed in the first place. So, that situation recent decision from 2020. This was the case about asylum applicants who escaped from Afghanistan because they were Sikh family, people of Sikh religion. And reality is that for Sikh religion people today is almost impossible to live in Afghanistan because Muslim part of majority of Afghan population are, softly saying, are not very friendly. And those people living in Afghanistan, Kabul, they simply 1 year before fleeing Afghanistan, they decided not to let their children go to school in order to prevent them from being attacked, to suffer harassment. So those people already were not allowing their children to go to school. And also in the case, the court itself admitted that even it was not safe to allow Sikh women to go outside their house alone without male escort. So this is the situation. And the number of Sikhs in Afghanistan is going down. They are leaving Afghanistan. They had 8 churches of Sikh religion, now only 1 left, and people are afraid even attend that church. This is the situation of Sikhs in Afghanistan. European Court of Human Rights decided, first, that as Sweden decided that situation is not so bad for Sikhs and they could go back to Afghanistan, they are not going to make their own assessment about the facts, which were already established by domestic courts. And also, they believe that those Sikhs, they failed to prove that their immediate circle is facing that risk, and they failed to prove some limited indications that risk for them is very high. So their logic is that as we still have Sikhs living in Afghanistan, it means not all of them are in danger. So those who would like to get asylum or to get protection under Article 3 of European Convention must prove some limited indications or danger to their immediate circle. Sorry, this is, in my opinion, again against principles of asylum law. Asylum law, we have very clear principle that we could not ask differential risk. We cannot ask applicants to require to establish a risk of harm which would be above that of others similarly situated. So, if we have situation that Sikh people in Afghanistan having children are afraid due to physical danger to their children, to let their children go to school, to let their wives to go outside to alone to walk on street. Sorry, this general situation is bad enough individually for each Sikh family having children and having women. And we, in my opinion, we do not need additionally to ask some additional special criteria to make their danger somehow higher. No, that general danger is enough. And going back to Belarusian situation, that's why I'm afraid that Belarusians would not get their protection. Because yes, all people participating in demonstration, they participate in the same demonstration, and they could not say why danger for some of them is somehow higher. And also, especially keeping in mind that European Court of Human Rights could propose them, okay, don't express your political opinion for 4 months, you know. Now the situation is hot, Oman is beating everything. Keep your political opinion to yourself for 4 months, and then, okay, go and demonstrate. So having this type of standards in European Court of Human Rights practice, I'm very skeptical that those people would get protection under Article 3. So just now, I need to stop here. Time is already, I'm over the overall time. So I'm just putting on the slide with the conclusions where I am simply repeating what I have just told. That, in my opinion, in order to achieve the same level of protection and compliance between protection under Article 3 of European Court of Human Rights and protection under asylum law, the following developments in practice of European Court of Human Rights are needed. So, European Court of Human Rights should not recognize the protection of non-state subjects other than organizations controlling the state or substantial part of the territory of the state and operating an effective legal system for detection, prosecution, and punishment of acts constituting the violations of Article 3 of Convention. Court should not recognize the expectation that asylum seekers would have to hide their sexual orientation, religion, political opinion, etc. Court should make its own assessments of facts instead of accepting the assessment of the domestic. Okay, sorry, maybe I have not elaborated on this. Just a couple more observations. Asylum law is not like other fields of law. I know the principle that court is not the fourth instance and they are not going into one more evaluation of the facts. But contrary to other fields of law, in other fields of law, if you claim, you must present formal evidence for your claim. In asylum law, this is not the same way. In asylum law, you tell your story. Your story is evaluated together with country of origin information. You don't have formal evidence. So if in asylum law, you decide not to evaluate, not to make your own assessments of facts, not much sense to examine that case at all. Because if you trust governmental assessment of facts, law would not help here. You already missed the fact which was decisive for issuing negative decision regarding Article 3. And fourth, that European Court of Human Rights should not require the differential risk, namely the risk above that of other similarly situated. Thank you. Finishing.
Thank you very much for a very interesting presentation. And now I would like to open the discussion. If, let's see, in chat, we don't have any questions. Does somebody have any reflections or would like to have a question to our third part speakers?
Can I ask one question to Laurynas?
Of course.
Laurynas, hello. Laurynas, we're always discussing courts issues with you, I think. So I was following very much your presentation, and it was very interesting to listen, for example, about different gaps you are raising as regards the jurisprudence of the European Court. And I have a very specific question concerning your one conclusion that the European Court of Human Rights should make its own assessment of facts instead of accepting the assessment of the domestic courts. But of course, I think you know quite well that this is one of the principles of the convention system, subsidiarity principle, and of course the state parties to the conventions, they're always asking the court very strictly to follow the assessment of the courts, and in cases like the court is evaluating facts by its own assessment, so then the states are criticizing the court a lot. How do you feel, for example, as regards your suggestion in asylum cases, taking into account this principle of subsidiarity of the convention system, and especially Protocol 15, where this principle is even enshrined in the text of the protocol? Thank you.
Okay. I'm sorry, could you still hear me? Because I'm a bit confused now with technology. I see Danute, I'm not sure I'm also online.
Yes, we can hear you.
Thank you, Katarzyna.
All at the same time.
So, like I have just told, I will repeat. In asylum law, it is not the same like in administrative or civil law. In civil law, if you claim something, you must prove with formal evidence. And the way you establish the fact, you check claim and whether it is supported or not by evidence. So this is how it is done in civil or administrative law. In asylum law, it is not possible to separate law from facts. In asylum law, facts actually are law. Because in asylum case, if you want to apply principle which is called benefit of the doubt, which is legal principle, you must take into account facts, story by applicant, country of origin information, and then make your own assessment. Otherwise, you cannot examine asylum case. So I would not say that this is against principle of subsidiarity. This is peculiarity of asylum cases and standard of proving and evidence in asylum cases. I think if court understood that peculiarity, they would understand that this is not against principle of subsidiarity.
Thank you for the answer. I don't know if Professor Jaceni is satisfied with the answer.
Of course, I'm satisfied. We can discuss it for hours, I think, but I would like to leave some time for the speakers as well.
Thank you. Does anybody have any further questions? Yes, Professor Žilinskas, you're welcome.
I would like to ask a question for presenters Piotr and Kaja. It was indeed very interesting analysis. And so my question would be, first of all, so how do you think, is there a chance that that Kurdish people that suffered most in these, and actually perhaps still suffering most in these Turkish operations, what we call, do they have a chance with application to European Court of Human Rights? I mean, do you think that the current situation on the ground is enough to prove that we have effective overall control as it is requested in the cases of European Court of Human Rights? Thank you very much.
Piotr, maybe it's your part. Although I can shortly just put
actually, this is a question which affects both of us. So maybe Kaja, do you prefer to go first or
I can just have one short answer to that. I think that it's of course an extreme situation for people there, and but we cannot underestimate their organizations. They have also a very huge lobby, so their victims are not left alone. Although having said that, we also looked at the Little Green Man case that was filed in 2014, and there was still no hearing. So even if the victims' complaints are admissible, I think it will take a lot of time to hear those cases due to the political context. That's all from me, and to you, Piotr.
Actually, I'm afraid I need to agree with Kaja, and I think that, well, at least some of the participants are from the countries which are highly affected by a modification of a modern democracy, and Poland is one of these countries. And I'm afraid it's very unfortunate that we cannot rely on a speedy European Court of Human Rights trials, because certainly European Court of Human Rights is a very slow grinder. As Kaja mentioned, these cases from 2015, 14 are proceed. So I'm afraid that it won't be easy to find a quick solution for, as you said, for Kurdish population in northern Syria. Saying that, I also strongly believe that we have little things to left. I mean, there is no many other places where the Kurdish population or I don't want to find this our case as exclusively applicable to Kurdish people, because affected by the northern Syria operations are not only Kurds but also other groups living in northern Syria. But in general, I think that well, I do hope that those cases will be proceeded with more speed than average for European Court of Human Rights. In terms of this effective control and collection of evidence, this is extremely difficult to collect any type of reliable evidence in northern Syria due to the fact that well, this is still ongoing conflict, and it's always very difficult to find in a most independent way that crimes were committed or violation of human rights, especially that basically no one is interested in exposing a nature and a scale of human rights violation. Syrian government specifically is not necessarily the most keen explorator of a human rights violation in Syria. The same Turkey. So it won't be that easy to find a solid evidence. On the other hand, we have over-present social media, Facebooks, YouTubes, where everyone can record particular crimes. Some crimes were I don't know how to say, but I think stupid enough to record their own crimes and then publish it online. So this definitely may result with finding a proper evidence for a case law. And obviously, I don't know whether I address all your questions.
Okay, thank you very much. Maybe there are more questions.
Okay, we see that there are no more questions so far. Does anybody has any reflection that would like to share with us? Okay. Okay, we don't have any
participants. So do we have any participants alive now? Okay.
We see that our participants are already a bit tired, maybe.
It's just before the lunch.
Yeah.
Okay.
Maybe I can make some reflection, given the fact that I'm not a scholar specialized in, let's say, European regional system of the protection of human rights. I'm much more, let's say, educated in law of armed conflict and this public international law. But every time I'm dealing with the Strasbourg Court, jurisprudence and case law, and basically that when looking at specific cases, I'm not dealing with the politics of the court and its structure and politics that is behind at the state. I have this impression that there is it's very hard to grasp what are the rules, and how Professor Laurenas said that there are those gaps, and there are those specific autonomous notions, and they are not only autonomous to the regime of the court, I think, but they are autonomous to each case. And therefore, I'm interested in your opinion as a community of scholars dealing with that probably on daily basis, because especially from this third panel, it seems that there are there is a lot of criticism directed at the court, and I just want to have the confirmation, or maybe a critic of my opinion, whether it's something that it's somehow frustrating, probably, but is it true? Is it only in those cases of armed conflict that are basically something very peripheric to the main topics of the convention? So I would like to hear some voices on that. Thank you.
Yes, please, Laurinai.
Okay, I could continue in my style. My colleagues know Justinas is already smiling. I'm very critical about everything, actually. But talking about Strasbourg Court, I would say that yes, if you start to understand some specific field more deeply, immediately you would find gaps in European Court of Human Rights practice. As long as you are on the general level, you are okay. They sound nice. But if you start, let's say, to understand better minority rights, you would say that, that Strasbourg is not very sensitive towards minority rights. If you start to understand children's rights, you would find gaps regarding protection of children. So, you know, maybe going back to the initial ideas which were told by Professor Egidijus Kūris about why, according to Vienna Convention, Strasbourg is limited, they could not rush, they must be very careful interpreting the convention, and so on and so on. I think that judges in Strasbourg, they understand, yes, they understand their role very carefully. And I get the impression that they kind of wait till European consensus. You know, they are not the first. They are waiting till majority of their countries already solve that problem domestically, and then they rush rest of the countries. But we are not the pioneers to say, the first to say, let's rush everybody. So then you start to understand any field, you know the best practice from different jurisdictions, and you see that Strasbourg is behind. Strasbourg is behind, and maybe this is how they understand their role. As human rights advocate, I would prefer more proactive idea, because the same professor, Mr. Kūris, we all know in Lithuania, he discovered the spirit of constitution. And he is very, very good in interpreting legal documents. So I'm pretty sure he would find their way to be very human rights, you know, friendly in interpreting convention as well. So sorry, provocative, but you know, just answering the question, Justinas.
Thank you very much, Laurinai. And maybe I will continue in a spirit of practice, not in the spirit of constitution. And I see that Laima is online. And well, yes, I would have one small question to Laima and one small question later to Gergely. Gergely, excuse me. So Laima, we are speaking about women in crisis, and you pointed out a lot of problems that actual women are facing, and we have no doubt that probably it is like this. However, are there any good examples of good practices during especially lockdown, quarantine, that can be an example of for the other states how to deal with those issues? Because we know that, okay, human rights court is insensitive, as Laurinai told us. Institution, and in majority of the countries, institutions are maybe not the question that they are insensitive somehow. However, probably it's a new situation, and not everywhere is clear how to act in this case. So, but maybe you know any good examples that could be followed by the other states. Thank you.
Thank you. Well, I don't know about very good examples, but I think that even during these kind of shameless populist politics, because right now what we're dealing with, both in Russia, in United States, sometimes in Poland, we deal with sort of shameless populist politics. And I think it is in a way a little bit a backlash to human rights shaming, because countries are in a way ashamed when we deal with one after another decisions that show them quite clearly what the gaps are. And now we see a wave of new populists who are saying, well, I'm not ashamed, I'm going to be outrageous. And I think that's a bit dangerous. But even in the context of this shameless politics, we still see very good examples when the courts are actually independent, when the courts are actually following both the rule of law and the spirit of law. And that can be in any kind of country, even in Poland and Lithuania, we see these examples everywhere, you know, brave courts that are dealing with actual law rather than sort of emotional politics. Because I do believe that we are kind of used to looking at law as something formalist and technocratic. I think it's in a way a legacy of Soviet Union, which was quite technocratic. But in reality, it's very much related to what is the political context, what is the cultural context. So I see these examples when women's rights are actually defended. For instance, I know that in Sweden there has been a reform after the Me Too movement of the sexual violence law. And they say that it works now much better than it used to work. Of course, that can be discussed as well. But I think that this is one of the sort of bad moments, dangers of the COVID-19, that violence is no longer treated so seriously. And then we also have recommendations adopted at the UN level, International Labour Organization, World Health Organization. They came up with guidelines what to do in order to prevent women's rights violations during the COVID-19 and minority rights violations. And I think it's there. It's just both the legislators can use and the governments can use these guidelines. So these are the good practice examples, or at least recommendations.
Thank you. Okay, I should ask one more time. Does anybody have questions? Okay, so if I can proceed with one small question to Gergely. You are speaking about the closure of internet, about closing websites, and you are giving some map with a lot of countries showing that internet is actually being well, closed to some extent, some web pages, and did it well, did the pandemic give rise or somehow enhanced these internet limits? And was it the pandemic, or was it the somehow impossibility of the states to cope with all the situation and trying somehow to limit access to some information for the state? So how do you think, has had the pandemic the direct effect on that limiting internet in Europe? Thank you.
Thank you for the question. To be very honest, I think nobody knows the answer for that. I mean, I think what we could, I mean, the numbers are growing, that's for sure. I mean, there are more and more state of emergency in different countries where government could do more against the freedom of speech and freedom of information. But I think that I could answer to that question a year later, because then we will see the numbers and we could compare the numbers, and then we could see if that's only our suggestion, our thinking at the moment is that the situation is getting worse. So these are not because of the pandemic, but the situation is getting worse. And some governments, even in the EU, are trying to hide their intentions behind the pandemic. But to be very honest, I don't know the answer. So we are watching the numbers closely. We are analyzing them, but at the moment I can't tell you. I can't give you the answer to that.
Thank you. Let's hope that your, watching and observing will result in some publications that we also can read and compare the numbers. Dear participants, do you have any last comments, last questions for the finishing of our session? Okay, so I see that the silence is the answer. So I would like really to thank you for all of you in this session, and for all of you in all these conferences that took part and were with us during all that conference, and for the great presentations. But first of all, there is very good Lithuanian telling that alone in the field is not a warrior. And first of all, I would like to thank very much to my colleagues, to Professor Žilinskas, to Professor Danutė Jočienė, for the great contribution, cooperation in organizing this event. I would like also to thank to our director, Professor Katuaka, who supported us in all of this. But also I would like to thank to my PhD student who was helping, Gediminas Sožiūnas, who was helping to handle all the technical issues during all the event. Everything went quite smoothly. It was our first fully online event. So if something happened, it's not our fault, it's fault of internet, of course, and technical issues. So thank you for all you one more time. And with this note, I would like to end our event, and let's hope we will see ourselves all together maybe in future, already live, not online. Thank you.
Thank you, bye.
Bye.
Thank you very much. Bye-bye. It was a pleasure to see you. Have a nice day.
Yeah, have a nice day.
Thank you.
Have a nice day.
Thank you.